You didn't signal.
Kia, are you ready?
You didn't do that one more time.
Got that? Okay. The House Committee on Elections will come to order. The clerk will call the roll.
Chair Smith,
Here?
Rep. Busey,
Here.
Rep. Burrows, Rep. Capriglione, Rep. Deala, Rep. Manuel, Rep. Morales, Rep. Swanson, Rep. Vo.
The quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. Due to the number of witnesses we have registered and to accommodate all who wish to testify, there will be a time limit of 2 minutes per witness during the public testimony period. Committee members, as a reminder, please remember to check out the publicly available comments. These comments are left by the public on each agenda item in our hearings. Comments are open until the end of the hearing and are posted upon adjournment from our hearing.
I'm going to flip to the bill because this is voting.
And I will say, given the number of witnesses we have, I do intend to move this along. And I would just admonish you that if you find yourself saying the same thing that everybody else has said, maybe we shouldn't be saying it. Trying to be nice about it. But if you would please remember and be respectful of everybody's time given the evening time that we're starting. The chair lays out Senate Bill 221 and recognizes Representative Paul to explain the bill.
Thank you, Mr. Chairman. Members, Senate Bill 2221 came after numerous citizen and municipalities encountered problems when facing various ballot initiatives and charter challenges from 2017 to 2021. The city of Houston is an example. They were reprimanded 3 times by the Texas Supreme Court over their inability to either draft proper ballot language or follow proper procedures when responding to a petition process. The examples are the HERO, Houston Equal Rights Ordinance, the HERO ballot language. The city had their own competing ballot language, was overturned by the U.S. Supreme Court, and rewording of the drainage fee ballot language, the city's language, was overturned by the Supreme Court. Greater uniformity is advisable when certain initiatives are put before the voters in order to ensure fairness for all involved. Senate Bill 221 seeks to address these issues by providing requirements for certain petition requesting an election by ballot proposition. In order to guarantee citizens uniform and fair elections, Senate Bill 221 outlines a process that must be followed by home rule municipalities to propose charter amendments and citizen-driven petition referendum, and establishes safeguards to ensure that ballot language accurately describes the proposition being placed before the voters. Specifically, the bill standardized forms and removes overbroad restrictions when submitting petitions, removes ambiguous statutory language, and establishes a uniform process for citizen-driven referendums, and allows an objective review of ballot language being put to the voters. Thank you, Mr. Chairman, and I reserve the right to close and answer any questions.
Thank you, sir. Members, any questions for the representative? Any questions of the representative? Thank you.
Thank you, sir.
It's all right. Is she here? The chair calls Susana Carranza. Susana Carranza? I show Susana Carranza is registered against the bill, SB 221, and testifying on behalf of herself. She's not here to testify. The chair calls Alan Vera. Members, just as a reminder that Representative Capriglione, would you grab him real quick? I just wanted everybody to know, after we get finished with this bill, we are going to vote on about 16 bills. So I just didn't want anybody to run off too far, at least. Okay. You are Alan Vera here testifying on behalf of the Harris County Republican Party Ballot Security Committee and for SB 221, is that correct?
That's correct, Mr. Chair.
Thank you, sir. Go ahead.
The problem of misleading language in ballot propositions is real, and it's frustrating. We previously gave this committee an example of the 2015 City of Houston ballot proposition calling for imposing term limits on city council. The language led voters to believe the proposal was to tighten up city council term limits when in fact they were adding 2 years to a city council's eligible term. This bill provides an appropriate process for review of proposition language, both through the Secretary of State and through the civil court system. It provides appropriate guardrails and adds that cities must pay the legal fees of the plaintiffs if the city loses their appeals in court action. It provides better guidelines and protections for voter petitions to prevent city secretaries from arbitrarily disqualifying validly submitted petitions. The bill clarifies the rules of engagement on city ballot propositions and on voter petitions, which can lead to ballot items. Both areas need improvement and greater clarity. We urge the committee to report SB 221 favorably to the full House. Thank you.
Members, any questions of Mr. Vera? Thank you, Mr. Vera. The chair recognizes that Chairman Burrows is present. The chair calls Thomas Burrows by chance. You are Thomas Burrows. You're here testifying on behalf of yourself and your 4 SB 221.
Yes.
Is that correct?
That's correct.
Thank you,
And
sir. Go ahead.
unless your family's from Grunby County, Tennessee, we're not related.
There's probably someone way back when.
Yeah. Okay, I'm here to talk about 1661, put in by Senator Hughes. The issue with this is I'm an IT professional person, a lot of years, worked inside Cheyenne Mountain in Colorado Springs at IBM as an operating system programmer. So what exactly is a cast vote record? Is this defined someplace? This is, you call me up here.
221?
For SB 221.
Well, I apologize, and I'll pass on that.
I'll tell you what, you are registered to testify on SB 221.
Yeah, well, must have been a mistake.
Oh, okay, all right. Well,
Yeah,
hold
sorry
on.
about that.
Hold on just one second, then.
He
So-
still testified on 221, so we have to record it as testimony.
You'd have
But
to request it.
your position on the bill?
What did you
Do
say,
you
ma'am?
have a position on this bill?
I'm in favor of it.
You are in favor of it?
Yes.
Okay, well, we'll just keep you like you are. Thank you, Mr. Burrows. Members, any questions of Mr. Burrows? Thank you.
Thank you.
The chair calls Wes Bowen. You are Wes Bowen. You're here testifying on behalf of yourself and your 4 SB 221. Is that correct?
I am.
Sir, go ahead.
I think after the bill layout and Mr. Vera's testimony, out of respect for everyone's time, I'll just yield the balance of my time. And I am in favor of the bill, and I recommend you report it favorably to the full House.
Well, thank you, sir. Members, any questions? All right, thank you. The chair calls Linda Curtis. You are Linda Curtis. You are here testifying on behalf of the League of Independent Voters of Texas and yourself, and you are neutral on SB 221. Is that correct?
Yes, sir. I feel a little sheepish about being on the bill because I mostly support this bill and have been supporting it for years because Senator Betancourt has been trying to get a bill like this passed for a number of sessions. I'm not at all a neutral party on this. I've run a bunch of citizens petitions. He has a reference in one of our cases in Bastrop where the city of Bastrop kind of jacked us around and didn't help us with our ballot language, and part of the measure failed. So again,
So I'll tell you what.
I'm going to tell you why we're against it. I mean,
Let's just make sure that we're on the right page here, because you've kind of gone over here and then went here, and
yes.
If you really are in favor of this bill, we don't want to screw this up. So-
Okay.
Because it could. So
Oh.
you are Linda Curtis, you're on behalf of the League of Independent Voters of Texas and
Yes, sir.
yourself, and you are neutral on this bill, is that correct?
I was going to speak on the bill and explain it. I'm getting right to why we're on the bill right now.
All right, well, let's just start right here and just tell me why you.
Here goes. Real quickly, we don't see in the wording of this bill something that tells us how the Secretary of State is required to tell petitioners and/or municipalities what's wrong with the ballot language. That's our first problem. The second problem is we don't see a way for this to sort of get adjudicated, I guess is the right word. I'm not an attorney, okay, but when does court action come into play? We didn't see that in the bill. So that's why we're on the bill. Otherwise, we really like it.
That's very good.
Thank you.
Thank you, ma'am. Hold on just one second. Members, any questions? We appreciate you. Thank you very much. The chair calls Katya Arisman. Good evening, Ms. Arisman. Good to see you again. You're here on behalf of Common Cause Texas and yourself, and you're against SB 221, is that correct?
Yes, sir.
Go right ahead.
Thank you, and we're trying not to duplicate, so I'll try to keep this pretty quick. We're against this bill specifically because of sections 1 through 4 of the bill. I believe some of our organizational partners are going to get up and explain some of that testimony. We didn't want to repeat it, but outline that this bill does not include requirements as to what the Secretary of State needs to do to provide reason for rejection or give a two-way street as to allowing the city to contest that election or challenge what the ruling was in order to provide the local authorities to have more accurate context as to what the ballot proposition language might have intended to say whenever it was being brought to the Secretary of State when reviewing this petition. The statement of intent for the bill says that it's to ensure greater uniformity as advisable for certain initiatives, but our opinion is that this bill would go far past that goal. As written, it doesn't enable cities to challenge the reason for rejection or provide new language when recommended from the Secretary of State. And the period that's outlined by the bill does not give enough time for cities to be able to implement some recommended language with enough time whenever having to create the ballots. Finally, we would urge opposition on Senate Bill 221 on the grounds that it also adds undue expectations and responsibilities to the office of Secretary of State, which should be a principle not in the office of a partisan appointee to oversee these local ballot initiatives, but also the fact that the bill lacks a fiscal note or appropriations in order to provide the staff capacity to review, potentially rewrite, and administer the local ballot initiative language for potentially any city across the state, which is especially concerning given the low threshold for rejections. So I think some of those other concerns will be outlined by my partners, but we urge opposition to 221.
Members, any questions?
So if a municipality or a petition initiative is worded incorrectly, indefinite or inaccurate or misleading, what would you suggest a remedy to be to fix that prior to the election?
Yeah, I think it's a really good question, and I do think some of our partners are going to outline some other recommendations given the more specifics on the mandamus clause. I think that right now the statute of the bill doesn't specify court action for the city to challenge what the recommended language from the Secretary of State's office is. So not to say that, being able to correct language of a ballot proposition that is maybe, not in good faith or maybe incorrectly worded is not needed, but the fact that this current lack of a two-way street on the mandamus is maybe not the best way to go about that reform.
I'm reading the bill, and it doesn't necessarily say that mandamus could be brought by only one party. I don't think it's what it says. So I think it is a two-way street, the way I read it. Maybe I'm mistaken, but have y'all looked at that?
Yeah, I think we have, and like I said, we didn't want to duplicate, so I think some of our partners are going to go into that more clearly, and we maybe registered in the wrong order to be able to provide that context first, but I think our initial reading of it is the fact that it does not provide that check-back system if the language is provided by the Secretary of State upon that third rejection of the language that the city proposes. There's no ability to really check back on that recommended language that's being provided back to the cities, and so that could potentially be concerning with the lack of feedback on that process.
And do you expect another witness here today can talk about that?
I think so, or if that isn't sufficient, then we can always come by your office tomorrow and provide some better answers.
Thank you.
Yeah, absolutely. Thank you.
Ms. Arisman, can you tell me who that witness might be so I can call them up next?
I think they'll be up in the next few. I'm not really sure which of our colleagues is going to talk about it, but I think it'll be answered by the end.
Okay, all right. Members, any other questions? Thank you, ma'am.
Yeah.
The chair calls Emily Abbey French. Good to see you, Ms. French.
Thank you.
Now, am I pronouncing your middle name correctly?
It's EB.
I didn't think I was. I thought
But I answered everything.
All right, Emily E.B. French.
That's why, yeah, that's why I changed it.
You're here on behalf of the Texas Civil Rights Project, and you're against SB 221. Is that all correct?
That's correct.
Go ahead.
Our main concern with this bill is sort of the back and forth that Katya referred to. The secretary requesting the city redrafting the proposition and correcting the defect up to 3 times, after which point the secretary can just redraft the proposition themselves. Our issue with that is that the review process in the bill doesn't do anything to necessarily improve the language of ballot propositions. It doesn't direct the SOS to explain why they rejected ballot proposition language. So a city could find itself missing the objectionable language, scrambling to correct the language that the SOS didn't find objectionable, and resubmitting it only to be rejected again. And then after 3 rounds of that sort of guesswork, the city would be unable to work on any of the bill's language at all from our reading. And I'm happy to talk about that in just a sec. Overall, we think this bill will limit local government's capacity to actually prepare ballots for an upcoming election. And that's why we ask the committee not to report this bill favorably.
Okay. Members, any questions? Representative Morales.
Is there a process in the bill that if there's a problem between the Secretary of State and the municipality, who irons those out, or do they go to the court?
So our reading was that the Secretary of State would be able to challenge the municipality's language in court, but it wouldn't necessarily be a two-way street. If we think it would be a two-way street, I would love to see that explicitly in the bill in a court proceeding. But.
Do you already have proposed changes, wording, and changes that you would like for us to take into consideration?
We can definitely look at some of that. Yeah, absolutely.
Thank you. Thank you, Mr. Chair.
Yes, sir. Members, any other questions? Thank you, Ms. French.
Thanks.
Good to see you. Chair calls Andrew Hendrickson. Good to see you again, Mr. Hendrickson.
Thank you.
You are here on behalf of the ACLU of Texas and against SB 221, is that correct?
That's correct.
Go right ahead.
So first of all, I just want to raise that we think it's an unnecessary infringement on local control. We do see some separation of powers issues here. The SOS being a member of the executive branch, they are making a determination that we do not believe can be challenged by the city or municipality regarding the clarity of the prop language. As the CCA stated in Financial Commission of Texas v. Norwood, exceptions to the constitutionally mandated separation of powers are never to be implied in the least. They must be expressly permitted by the Constitution itself. There is a catch-all provision in the section regarding the SOS that states that the SOS shall perform such other duties as may be required by law, but I don't think that's enough to get you around judicial review because it's not explicit enough and could create a situation where the legislature could essentially give the SOS power to circumvent the judicial review process in all sorts of circumstances, if that's how you're reading that provision of the Texas Constitution. I think the issues that were raised earlier about the mandamus action, if you're looking at it, at the language about the mandamus action can be brought by a person to compel the governing body of a city. So it can't be brought to compel the Secretary of State to change their determination about the language or to change their language. It can only be brought against the city. So I think that, to get to Representative De Ayala's question, I think that's the issue there. We do think there's a potential for abuse of power if there's a politically unpopular with the executive branch ballot prop on a local ballot, because you don't have to provide a reason. You can just, the SOS could just reject 3 proposals for the language out of turn, redraft it themselves, and then there's no mechanism by which the city can then go forward and challenge the SOS language under the exact same standard that, you know, they are being required to comply with. The idea that it's not misleading, inaccurate, that standard that's laid out in the bill. So those are sort of the issues that we see with the bill. Do think that there are some guardrails that can improve it, but we may still be against because of the local control aspect. But I do think there are some options potentially for creating some process by which, you know, there could be, you know, more judicial review and ensuring that the SOS is complying with those same requirements that the cities are required to comply with.
Okay. Thank you, sir. Members, any questions? Representative De Ayala.
I've heard this testimony before, and you may have been in the room, but the way our Constitution is in the state of Texas, the body that is ultimately responsible for good, accurate, fair elections is the Secretary of State. Is that your understanding as well?
Subject to judicial review, and because there's no mechanism in this bill that allows the Secretary of State's determination to be challenged regarding the ballot prop language, I think that's where you get into the problem, right? They don't have to articulate their reason, and then that reason can't be reviewed by a court. If there was, I don't think you necessarily see the separation of powers problem here, because the issue is that the SOS's determination regarding the ballot proposition, as it's drafted now, in our opinion, is final. And is a final judgment on the merits, and that really is what's the role for the court, for the courts and the power more properly attached to the judicial branch.
Is it your interpretation of this bill that it precludes judicial review?
That would be my interpretation. I don't see where there's any cause of action that the city could file because there's no against the SOS based on the SOS's language, and that's where we see that two-way street issue.
And you're saying without an express provision here that it means there is no remedy?
I believe so. I believe in this context there wouldn't be you would, and because there is an express provision that applies to a voter for the mandamus, I think there's an implication that there's not. And I think if that is the intent of the bill, there's no reason it shouldn't be spelled out, especially because with ballot prop language and the time constraints of printing ballots, you would want to make sure there were good timeframes involved that would allow that judicial review to happen quickly, so that the ballot prop could in fact be placed on the ballot if it was based on valid petitions.
Okay. I just don't read it that way. I think without a specific preclusion, then it's not precluded. That's the way I read most statutes. But we can talk about that later.
Absolutely.
Any other questions? Representative Morales.
Thank you. You are representing the ACLU, right?
Yes.
Texas.
Of Texas, correct.
All right. So I can understand where you and Ms. Emily have the concerns with respect to the section related to mandamus actions. It's only a one-way street where it only allows for the city to be sued and taken to court for purposes of determining whether the wording was appropriate.
Correct.
I can understand that, and I think that needs to be modified also, because what if we end up not saying, what if we end up with a rogue Secretary of State individual or a group of individuals that just won't take any of the proposed changes from the city? I think taking a step back, we first need to acknowledge that cities sometimes get it wrong, right?
No argument there, not suggesting that, ballot prop language shouldn't be clear, and really our interest is always with making sure the voters are able to cast an informed, choice on a ballot prop. So I think, yes, I think that's probably a fair statement.
Now, when city charter amendments are being amended or, taken out to the public, for a formal vote, do these sorts of actions also require a pre-clearance process on this wording? I'm wondering, because I can't.
I can follow up on that. I'm not sure I know the answer to that clearly off the top of my head.
Because I remember in representing some municipalities, sometimes when the city charter amendments needed to be modified, we always had to send the pre-clearance letter. But then when the Supreme Court
right. Under Section 5, the city charter would have had to have a pre-clearance process through the DOJ. That happened very quickly, and it was for a limited set of, violations of potentially of the Voting Rights Act. Okay. So not just about clarity, which is, what this standard is about, but about, very specific protections under the Voting Rights Act for diminishing minority voting power.
Got it. So in that process, though, I think we can all agree that the most efficient and resourceful way is not for the parties to end up in the court, because I think that's the last recourse that anybody would want, including all our constituents. You would agree, right?
Yeah, I think depending on the circumstances of how it's laid out, I think yes, I can understand why, especially given the time factors here and the fact that we're trying to get ballots printed timely, and they can be very expensive for both sides. I think there's merit to that.
So I can understand the concerns also that you all are raising with respect to the 3 chances and the Secretary of State not really letting you all know in the first instance, this is what you got wrong, here are the red line changes. So I think we need to work on those proposed changes. I'm saying this because I need you all's help in making sure that we have some language that I can feel comfortable in supporting.
Absolutely. I'm happy to meet with you or your staff after the hearing or, later this week whenever we have a chance to set that up and discuss how we could maybe put some more guardrails in place.
For the purposes of being resourceful, efficient, and making sure that it's addressed at the lower end between these two state agencies that should be working for every one of our constituents, okay? That's the purpose. I think if we can address it here on the low end, then we never have to see the court system, right? But in the event that we do, I also think that there's changes that need to be made to page 3, line 25, where it provides for the city is required to pay for legal services. Because I can envision sometimes maybe the city is the correct one, and a court can interpret that the city did everything right. And in fact, in that situation, we may have the reverse where the Secretary of State needs to pay for the city's legal fees. And so I would like for that also to be addressed.
We can take a look at that. I do think, part of that is ensuring that you don't have PACs paying for the city's legal expenses who are pushing the propositions to begin with. So I think there are ways to, sort of make sure that process is fair. I also would note in the mandamus process that does trigger, if there's a ruling against the city, it triggers this 4-year mandatory review process of every ballot prop by the SOS, which also could create potential problems for just, requiring extra process where there's no one complaining about a specific ballot prop.
Those are my comments, and if you can assist with any proposed wording, I'd
happy to follow up on that.
Thank you.
Members, any other questions? Thank you.
Thank you.
Mr. Henderson, appreciate it. The chair calls Christina Atkins. Good evening, Ms. Atkins. You are here on behalf of the Texas Secretary of State's office, and you are neutral on SB 221, that's correct?
Yes, sir.
Here is a resource witness for us.
Yes, sir.
Members have any questions? Vice Chair Busey.
Thank you, Mr. Chairman. Thank you for being here. What is the SOS's current role in ballot propositions and oversight? What do y'all do now, and what would change with this bill?
We don't really have a role in oversight of proposition language when it comes to local propositions like this.
So this would change that, and you would have that?
Yes, sir.
If there's this dispute over ballot language, isn't there already a mechanism for a court to make a determination and order corrective action under current law?
That's typically what happens now, yes.
How often, are you aware of how often disputes over language are occurring?
I don't have any data to support that, but anecdotally, it's not an uncommon item that occurs.
Oh, okay. Is there a way to get these stats to us before?
Probably not, because we don't currently have a database that contains all of the elections that exist out there, so I wouldn't have a way of gathering that information.
I think somebody brought it up earlier, so let me touch on it. With there being no fiscal note, no cost to the state or local, what extra resources does your office have to commit to this if you're given this now to review?
So that's
it'd be pretty thorough.
No, I appreciate the question and I appreciate the concern. We actually did have a fiscal note that we attached to the bill when it was submitted to the LBB, but the LBB stripped the fiscal note.
Are you able to share that with us?
I can provide to you what we submitted to them, and I can tell you that we were saying that we needed to probably hire 2 additional attorneys to handle the increased workload.
Yeah, I'm worried about this being an unfunded mandate. I feel like usually my bills go the other way with fiscal notes getting bigger. I appreciate your questions. Thank you.
Yes, sir.
Or your answers. Thank you.
Just want to make sure that you share that data.
The fiscal note, yes, sir, we can provide that to you all. Mm-hmm.
Thank you.
So, Ms. Atkins, I know you're always so willing to be of service and to do what it is that we ask you to do.
Yes, sir.
And I appreciate that very much. Is there anything about this, though, short of maybe hiring a couple more attorneys, that makes this unworkable, makes this difficult to deal with, makes this unduly burdensome for your office?
I think you identified the primary concern we have with bills like this would always be regarding the potential impact to our office as far as the workload and our ability to meet the demands and the requirements, since there are deadlines here. Mm-hmm. So that's always going to be our primary concern. Other than that, we're going to do whatever we need to do. I think one other point to consider is, there's been some testimony talking about, the nature of having an appointed official, the secretary being appointed and weighing in on local issues. I think it's important to remember that, anytime our office has authority to step in an ongoing election process or like a proposition review, we're going to exercise great caution in doing so, because that's, exercising some authority that's there. And so we have to always be cautious about how we do that.
Were you all consulted whenever this bill was drafted, or after the bill was drafted, or before?
I know that this bill or versions of this have been filed in the past, and I think there have been discussions with our office. I was not party to those discussions.
Okay, all right. But what you're telling me is that in terms of I'm assuming that you have some familiarity with it, how this is laid out in terms of the timelines and whatnot, you don't see any problems with being able to make that happen, short of whatever constraints there are on your ability to man it?
I understand what you're asking, and, the timelines are a little tight depending on how soon, an issue is raised or how soon a voter, wants to challenge a petition, but I think understanding the timelines that are at play and how important it is to resolve these issues timely, I think that our office would do everything within our power to move very swiftly in any challenges that come our way.
Well, Mr. Paul, you get with him and work with him. I know you guys could, if there's something that needs to be tweaked here, and we can quickly and make it this better.
Yes, sir.
If need be. But thank you very much. Members, any other questions?
I do.
Yes, Representative Morales.
Do you have an opinion one way or the other? I've noticed that whenever, we're dealing with Open Meetings Act and legal opinions that come from that, is usually Attorney General's Office, Open Meetings, Open Records Act, and those get processed through the AGs. Would the AG be an agency better suited to address this, or is it simply because the Secretary of State oversees elections? Do you have an opinion one way or the other?
I think that's a fair question. I think that there have been versions of this bill that have been filed before or that call for some kind of review process. There are some that put that power with the Attorney General's office and some that put it with our office. I think that's a point to consider, I think, when you all are looking at some kind of legislation to do some kind of review process. If it comes to our office, of course, we're going to do what the legislature requires us to do, but that is an alternative that's there.
Are you aware of there's a department already within the AG that oversees election wording or anything?
I don't believe there's anything that exists like that now, but there have been bills filed that would have a similar review process, but put it in their hands rather than the Secretary of State's office.
Okay. Now, you may be asked by Chairman Burrows if somebody from the AG's office is here, but I don't know.
Thank you, Representative. Members, any other questions? Any other comments that you want to make?
No, sir.
Okay, thank you.
Thank you.
Thank you very much. The chair calls Charles Cruz. Mr. Cruz, I show you are here on behalf of yourself that you're against SB 221. Is that correct?
It is.
Go ahead.
Thank you, Chair Smith, Vice Chair Busey, and committee. In the interest of time, the folks from League of Independent Voters, Texas Civil Rights Project, and ACLU have done a great job in explaining the major issue that I have with it as well, that there is no dialogue, that it's the Secretary of State could just reject it with no explanation as to why. That's my biggest opposition to this bill.
Okay, thank you. Members, any questions? Thank you, sir. The chair calls Bill Longley. Evening, Mr. Longley. I show that you are here on behalf of the Texas Municipal League, that you're against SB 221. Is that correct?
Yes, sir. That's right.
Okay, go ahead.
Thank you, Mr. Chairman, members of the committee. My name's Bill Longley. I am here opposed to this bill in its current form. There's been some discussion so far about the need for non-judicial avenues of reviewing city ballot language, and I don't think that's unreasonable. Many cities wouldn't have an issue with that concept in principle. The problem for us is that Senate Bill 221, while establishing a non-judicial review process through the very capable attorneys at the Elections Division of the Secretary of State's office, also simultaneously expands judicial remedies at the same time. As discussed, this would allow for more challenges of city ballot language while also waiving governmental immunity. The bill would also open up the city to a legal challenge for using the language drafted or approved by the Secretary of State's office, which we think is a mistake. We think that if this committee and the legislature as a whole determines that there should be some kind of state agency oversight of ballot language, that the administrative process to get the language reviewed serve as an alternative to a lawsuit. In other words, if a state agency reviews the language and blesses it, then the city should be protected from a lawsuit, not subject to more liability as SB 221 would do. Just as recently as last month, the Texas Supreme Court ruled in favor of a city, in this case it's the city of San Antonio, in properly placing a citizen proposition before the voters and drafting acceptable ballot language. In denying the interest group's challenge for the writ of mandamus, the court reiterated its hesitance to get involved in what they called judicial meddling, that's the court's words, and ruled in favor of the city in adhering to a longstanding commitment to avoid undue interference with elections. We agree with the Texas Supreme Court in this case and think that this bill promotes judicial meddling when there are adequate, acceptable pre- and post-election remedies already in the election code.
Members, any questions? Thank you for your testimony, Mr. Longley.
Thank you.
Appreciate it. Is there anyone else who wishes to testify on, for, or against SB 221? We have one taker over here. Is that Ken Moore?
That is Ken Moore.
Hold on
Yes,
just
sir.
1 second, Mr. Moore.
Did you register, Ken?
I think I registered for the bill. I did not register to testify.
Give us 1 second, please. Akia, I'm not showing his registration if you can do it on the iPad. Thank you. Kia's gonna help you register if
Oh.
you're not registered.
Representative Morales, we are about to vote.
Yes.
Okay, I just want to make sure. Just heard my cats over here, I'm sorry.
You know.
Yeah, that's right. No, we just have a hole.
Mono likes to scoot out.
Yeah, Mono.
Spread out.
Mono, are you in the naughty corner?
Which one?
Okay, you are now in there, sir.
Okay, Mr. Moore, the heat's on you here. Yeah, I see you're here on behalf of yourself and you're for SB 221, is that correct?
Yes, sir.
Go right ahead.
And my apologies for the delay. I really thought I'd registered on this thing. But
Not a thing.
the perspective I want to bring to this is that of an election judge. Because quite often we have ballot language, propositions, we have proposals to change charters, proposals to change the Constitution, what have you. And we have people come in there and they ask us, could you please explain what this means? Well, at the beginning of every election, we take an oath not to do anything or to say anything that would influence a voter one way or another on any of these propositions or who to vote for. And so our stock answer is, no, I'm sorry, I can't explain that to you. I said, I can spoil the ballot, you can go home, study it, come back, but no, I can't explain this to you. Having clear ballot language on these propositions would be very, very helpful if they can see what's in front of them and understand what they're looking at. That would be very, very useful. I am for this bill. I think it's good.
Thank you. Members, any questions? Thank you, Mr. Moore. Appreciate it. What's that? Where'd you go? Okay. Is there anyone else who wishes to testify on, for, or against SB 221? If not, the chair recognizes Representative Paul to close on the bill.
Thank you, Mr. Chairman. Members, just kind of want to point out a few things from listening to the testimony. Number one, Secretary of State gets involved in looking at all of our elections and reviewing election processes, so I don't really see how that's got anything to do with mixing of the different divisions of state. Also, there is a point in here where it says the registered voter eligible to vote in the election may submit the proposition for review to the Secretary of State. So it does talk about an ability for citizens to bring that to their attention. Also, the Secretary of State has 7 days to make the review and get it back to them so that we can have a quick review. It's in the law. And also, there's a process set up to make sure that court review is quick and speedy so that it has that review to get done and right. They knows that there is an election that's going to take place and the people are waiting and it's got to get done. So it sets up a process to make sure that that court action is quick and asks that it be sped up. So I think, and obviously a city always has the ability to sue if they so want to after anything. So I think most of this is not as justified as needed, and I think we got some good bill. Also, don't forget this has already gone through the people in the Senate. It's already voted by a vast majority over at the Senate side. And there is no fiscal note. The LBB gives us those. It's the same thing we use for all of our other decisions on fiscal notes. So ask for y'all's consideration and support to get this through to the floor, and I'd be glad to answer any other questions.
Members, any questions?
All right, thank you, sir. Appreciate it.
I would just ask that you spend a little time talking to Ms. Atkins from the Secretary of State's office.
I will.
You're all comfortable with that.
Yeah.
And I appreciate you. Thank you very much. If there's not any objection, SB 221 will be left pending. The chair hears none. SB 221 is left pending. We've got everybody here. We're going to vote. Members, we're now going to vote out several bills we've heard in previous hearings. The chair lays out HB 223 as pending business. Members, this is a bill we heard previously by Representative Cortez relating to the ballot application requirements for the election of a precinct chair. The chair moves that HB 223 without amendments be reported favorably to the full House with a recommendation it do pass and be printed and be sent to the Committee on Local and Consent Calendars. Clerk will call the roll.
Chair Smith.
Aye.
Vice Chair Busey.
Aye.
Rep Burrows.
Aye.
Rep Capriglione. Rep Deala. Rep Manuel. Rep Morales. Rep Swanson. Rep Bo. 9.
There being 9 ayes and no nays, the motion prevails. The chair lays out HB 315 as pending business. Members, this is a bill we heard previously by Representative Cortez relating to a statement by the Secretary of State regarding the furnishing of certain personal information on an application for a ballot to be voted by mail. The chair moves that HB 315 without amendments be reported favorably to the full House with a recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Smith.
Aye.
Vice Chair Busey.
Aye.
Rep Burrows.
Aye.
Rep Capriglione. Rep Deala. Rep Manuel. Rep Morales. Rep Swanson. Rep Bo. 9.
There being 9 ayes and no nays, the motion prevails. The chair lays out HB 453 as pending business. Members, this is a bill we heard previously by Representative Schofield relating to the use of public schools as polling places. The chair moves that HB 453 without amendment be reported favorably to the full House with a recommendation that do pass and be printed, and the clerk will call the roll.
Smith.
Aye.
Busey.
Aye.
Burrows.
Aye.
Capriglione. Deala. Manuel. Morales. Swanson. Bo. 9.
There being 9 ayes and no nays, the motion prevails. The chair lays out HB 862 as pending business. Members, this is a bill we heard previously by Representative Schofield relating to the cancellation of a person's voter registration on the notice that the person has acknowledged that the person is not a citizen. Representative or Chairman Capriglione offers a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none and the substitute is adopted. The chair moves that HB 862 as substituted be reported favorably to the full House with a recommendation that do pass and be printed. The clerk will call the roll.
Smith.
Aye.
Busey.
No.
Burrows.
Aye.
Capriglione. Deala. Manuel. Morales.
I'm a no, but I'd like to put on the record that I'm working with Mike to make sure that he addresses the LULAC settlement in the word.
So you are a no vote. Rep. Swanson? Aye. Vote?
No.
5.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out HB 1140, again by Schofield, as pending business. Members, this is a bill we heard previously relating to the voter identification required for submission of an early voting ballot by mail. Representative De Ayala offers a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that HB 1140 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed, and the clerk will call the roll.
Smith?
Aye.
Busey?
Aye.
Burrows?
Aye.
Capriglione? Deala? Manuel? Morales? Swanson? Foe? 9.
There being 9 ayes and no nays, the motion prevails. The chair lays out HB 1299 as pending business. Members, this is the bill we heard previously by Representative Noble relating to the signature required on a carrier envelope for a ballot voted by mail, changing the elements of a criminal offense. The chair moves that HB... Is she going to give us...
Different bill.
Different bill. The chair moves that HB 1299 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Smith?
Aye.
Busey?
No.
Burrows?
Aye.
Capriglione? Deala? Manuel? Morales? Swanson? Foe?
No.
7.
6.
There being 6 ayes and 3 nays, the motion prevails. The chair lays out HB 1671 as pending business. Members, this is the bill we heard previously relating to vote harvesting, creating a civil penalty by Representative Jeton. The chair moves that HB 1671 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Smith?
Aye.
Busey?
No.
Burrows?
Aye.
Capriglione? Deala? Manuel? Morales? Swanson? Foe?
No.
5.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out HB 2860 as pending business. Members, this is the bill we've heard previously by Representative Swanson relating to maintaining certain voter registration information and reviewing ballots voted by mail, creating criminal offenses. The chair offers a committee substitute. Is there objection to the adoption of the substitute? The chair hears none, and the substitute is adopted. The chair moves that HB 2860 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Smith?
Aye.
Busey?
No.
Burrows?
Aye.
Capriglione? Deala? Manuel? Morales? Swanson? Foe?
No.
5.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out HB 3449 as pending business. Members, this is the bill we heard previously relating to ballots voted by mail. The chair offers a committee substitute. This is by Representative Noble, by the way. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that HB 3449 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed, and the clerk will call the roll.
Smith?
Aye.
Busey?
No.
Burrows?
Aye.
Capriglione? Deala? Manuel? Morales? Swanson? Foe?
No.
6.
There being 6 ayes and 3 nays, the motion prevails. The chair lays out HB 3537 as pending business. Members, this is the bill we heard previously relating to a candidate's application for a place on the ballot for a party's primary election by Representative Manuel. Vice Chair Busey offers a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that HB 3537 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed, and the clerk will call the roll.
Smith?
Aye.
Busey?
Aye.
Burrows?
Aye.
Capriglione? Deala? Manuel? Morales? Swanson? Foe? 9.
There being 9 ayes and no nays, the motion prevails.
Yeah.
The chair lays out HB 3736 is pending business. Members, this is the bill we heard previously relating to a study by the Secretary of State on the accuracy of the information contained in the statewide voter information database. The chair moves that HB 3736, without amendments, be reported favorably to the full House with the recommendation that do pass and be printed, and the clerk will call the roll.
Smith.
Aye.
Busey.
No.
Burrows.
Aye.
Capriglione. Deala. Manuel.
No.
Morales. Swanson. Bo.
No.
5.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out HB 3749 as pending business. Members, this is the bill we heard previously relating to the provision of the reason for rejecting a voter registration application by Representative Flores. The chair moves that HB 3749 without amendments be reported favorably to the full House with a recommendation that do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Smith.
Aye.
Busey.
Aye.
Burrows.
Aye.
Capriglione. Deala. Manuel. Morales. Swanson. Bo. 9.
There being 9 ayes and no nays, the motion prevails. The chair lays out HB 4399 as pending business. Remember, this is the bill we heard previously by Representative Hayes relating to the plan for the operation of a central counting station. Representative or Chairman Capriglione offers a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that HB 4399 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed, and the clerk will call the roll.
Smith.
Aye.
Busey.
No.
Burrows.
Aye.
Capriglione. Deala. Manuel.
No.
Morales. Swanson. Bo.
No.
5.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out HB 5259 as pending business. Members, this is a bill we heard previously by Representative Toth relating to death records maintained and provided by the Vital Statistics Unit of the Department of State Health Services. The chair moves that HB 3736 without amendments be reported.
Sorry. 5259.
Oh, got that wrong.
Say that
All right.
sentence again.
I got the reading along. The chair moves that HB 5259 without amendments be reported favorably to the full House with a recommendation that it do pass and be printed, and the clerk will call the roll.
Smith.
Aye.
Busey.
Yes.
Burrows.
Aye.
Capriglione. Deala. Manuel. Swanson, excuse me, Manuel. Morales. Swanson. Bo. 9.
There being 9 ayes and no nays, the motion prevails. The chair lays out HB 4701 as pending business. Members, this is a bill we heard previously by Representative De Ayala relating to the review of ballot proposition language for certain political subdivision elections. Representative Swanson offers a committee substitute. Is there objection to the adoption of the committee substitute? The chair hears none, and the substitute is adopted. The chair moves that HB 4701 as substituted be reported favorably to the full House with a recommendation that do pass and be printed, and the clerk will please call the roll.
Smith.
Aye.
Busey.
No.
Burrows.
Aye.
Capriglione. Deala. Manuel.
No.
Morales. Swanson. Bo.
No.
5.
There being 5 ayes and 4 nays, the motion prevails. The chair lays out HB 3732 as pending business. Members, this is the bill we heard previously by Representative Guerra relating to requiring voting systems to produce a paper receipt. The chair offers a committee substitute. Is there objection to the adoption of the committee substitute? I hear none, and the substitute is adopted. The chair moves that HB 3732 as substituted be reported favorably to the full House with a recommendation to do pass and be printed. The clerk will call the roll.
Smith.
Aye.
Busey.
Aye.
Burrows.
Aye.
Capriglione. Deala.
Aye.
Manuel.
Aye.
Morales. Swanson.
Is it that funny?
Bo.
Aye.
9.
There being 9 ayes and no nays, the motion prevails. We try and keep it light here in elections.
I had to, she brought it out.
That's all 16.
All right, now, who we have here? We have Charles Cunningham.
Yes, sir. Let me get you there. Good work, team.
Thank you very much.
Yes.
All right. The chair lays out Senate Bill 825 and recognizes Representative Cunningham to explain the bill.
Good evening, Chairman Smith, members. Thank you for allowing me the opportunity to lay out Senate Bill 825. Under Section 212.028 of the Election Code, if a candidate desires to request a recount for an election, the candidate must file an application for a recount by 5 p.m. on the second day after the date of canvass. The need for SB 825 became apparent during the canvass of the November 8, 2022 election. Harris County canvassed on November 22nd, 2022, which is a Tuesday before Thanksgiving. With the above scenario, a candidate has only one day to file an application for a recount. As we are all aware, a race can change from one candidate winning to another candidate from the close of election day to the counting of the canvass. There is not enough time for a candidate to make a decision to prepare a request for a recount under the current code. SB 825 would give candidates one more day to file an application and would give an additional time if the deadline falls on a Saturday, a Sunday, or a legal holiday to the next business day. Thank you, Mr. Chairman and members. I reserve the right to close.
Any questions, members? Thank you, sir. Your right to close is reserved, and the chair is going to call Christina Atkins. Good evening, Ms. Atkins. You're here on behalf of the Texas Secretary of State's office, and you're on SB 825, is that right?
Yes, sir.
In your review of this, do you have any comments after your review of this bill?
No, sir.
Okay, members, we have any questions, Ms. Atkins? Okay, thank you very much.
Thank you.
The chair calls Wes Bowen. Mr. Bowen, you're here on behalf of yourself and you're for SB 825, is that correct?
I am.
Go ahead.
Yeah, I'll only say that I think it's only fair to extend for the holidays, the election departments extend all their obligated timelines by the holidays, so it just makes sense. I'll yield the rest of my time.
Thank you, sir. Appreciate you. If there's no questions of Mr. Bowen, the chair calls Thomas Burrows.
I'm in favor and I yield my time.
Can you come up here? We're going to just make sure we get this straight on the record. Mr. Burrows,
I'm in favor of this and I yield my time.
okay, so you're Thomas Burrows, you're here registered on behalf of yourself and you're for SB 825, is that correct?
That's sir, correct,
Okay.
sir.
Thank you.
Members, any questions of Mr. Burrows? Thank you. Appreciate it. The chair calls Charles Cruz.
He still has to come up.
Won't you come up here, Charles? I appreciate that, but we're just going to make sure You're Charles Cruz, you're testifying here on behalf of yourself and you're against SB 825, is that all correct?
That is all correct. As of this morning, I have since changed my mind and no longer wish to testify on the bill.
But your position is still good?
But your position is still the same?
Yes, sir.
Okay. Members, any questions of Mr. Cruz? Thank you.
Is there anyone else?
Is there anyone else who wishes to testify on, for, or against SB 825? If not, the chair recognizes Representative Cunningham to close on the bill.
Chairman Smith, members, thank you once again for allowing me the opportunity to present this bill before the committee. I ask for your favorable consideration that the bill be sent to calendars. I close. Thank you.
Yes, sir. Members, any questions? Thank you, Representative. Appreciate you. If there's no objection, SB 825 will be left pending. The chair hears none. SB 825 is left pending. Is he here? Yeah, okay. All right. The chair lays out Senate Bill 994 and recognizes Chairman Burrows to explain the bill.
Thank you, Mr. Chairman. Members, in 2019, the Texas Legislature passed into law a requirement that all candidates for a state or county office pay a filing fee or submit valid petition with signatures in lieu of the filing fee in order to be eligible to be placed on the ballot. Senate Bill 994 builds upon the government's interest in preventing voter confusion, ballot overcrowding, and the presence of frivolous candidates. Senate Bill 994 provides that a candidate may be administratively declared ineligible if the candidate fails to pay the filing fee or submit a petition in lieu of a filing fee. Senate Bill 994 also provides that the candidate who fails to submit the required filing fee or petition may be declared ineligible by the Texas Secretary of State. Mr. Chairman, I also have a committee substitute. This substitute would allow for all eligibility issues to be resolved before the ballot preparation is complete and will prevent unnecessary ballot correction that could be costly and could impact military and overseas ballots. With that, happy to answer any questions, and I would reserve the right to close.
Now, we have a substitute. Is that correct?
That is correct.
All right, so Representative Swanson offers a substitute. Members, any questions? Thank you, Chairman. The chair calls Christina Atkins. You are Christina Atkins. You're here on behalf of the Texas Secretary of State's office, and you're neutral on SB 994. Is that correct?
That's correct.
Do you have any comments that you wanted to make about this particular bill?
No, sir.
Members have any questions? Representative Morales.
Noticing the committee substitute provides for the executive committee to make a replacement nomination. And it cites to a section, I haven't had a chance to look at the section. Does that provide for a specific time window and a deadline in which the executive committee, or is it just open-ended?
So my understanding is that there were actually two components to the committee substitute that provided kind of a little bit more clarity on that level. One of them was for the replacement nominee portion. So if somebody's declared ineligible under current law, the party has the ability to make a replacement nominee. And my understanding is that language was going to impose a similar obligation on the replacement nominee so that we're not declaring somebody ineligible and then just immediately reappointing the same person and they haven't paid the filing fee or submitted a petition in lieu of that filing.
It does provide for the filing fee
Yes.
to be paid as part of the conditions, but I'm more concerned about the timeline and
timelines?
the deadline. Can you make sure that that is, if you,
And I can double check, yes, sir, but from my understanding, from what I was talking to the senator's office about the language and the potential committee substitute, we were talking about providing a provision in there that would tie it to candidates couldn't be declared ineligible or they could be declared ineligible up until 74 days before Election Day. So if that's in there, then we've got that timeline frozen, just as Chairman Burrows said.
so that deadline would also apply to the executive committee.
Yes, that deadline applies, that's the final deadline when it comes to ballot preparation for our November election. Everything needs to be done by that time frame in the election code. That's consistent with other provisions in the code that ends that time frame right there.
Can you just take a look at it? Because
Yes, sir.
I am having concerns over the wording.
Okay,
It says
of course.
ineligible under subsection F3 after the 74th day preceding the election day.
Yes, sir.
And then the replacement by the executive committee also references a nomination being made after someone has been declared ineligible under that same section F3.
I will read it again, sir, just to double check, but I'm positive, just from what you've described, that it should be fine. And the reason why is because that 74th day before Election Day, there's other code provisions that prevent you from being able to make replacements after that time already. So that is consistent with what all the other code provisions say, that cutoff date.
And I like it, I just
Yes,
think
sir.
I wanted to make sure that we didn't create some sort of
I understand, yes, sir.
problem that ended up in the courts.
But I will definitely review the language just to be sure.
Thank you.
Yes, sir.
I appreciate that. Members, any other questions? Thank you, Ms. Atkins. The chair calls Arthur DiBianca. Did I pronounce your name correct?
Exactly right.
Excellent. You are Arthur DiBianca here on behalf of the Libertarian Party of Travis County and yourself, and you're against SB 994, is that correct?
That's correct.
Go ahead, sir.
Last year, a candidate named Tommy Estes ran as a Libertarian for State Senate in District 5. Mr. Estes was the only opponent of Senator Schwartner, who was running for re-election. In August, Senator Schwertner, along with 22 other Republican nominees, filed a lawsuit in the Texas Supreme Court seeking to have their Libertarian opponents, including Mr. Estes, removed from the ballot. The lawsuit was unsuccessful, and in the November election, Tommy Estes received more than 76,000 votes, which was about 28% of the total. If this bill had been in effect last year, the people of District 5 would not have been well served. Mr. Estes would have been removed from the ballot, and over 76,000 voters would have been disenfranchised. They would not have been allowed to cast a vote for their preferred candidate. In fact, they would not have been able to cast any vote at all. The election would have been canceled, and the state would simply have reanointed Senator Schwertner into office. We do not want a system where the Secretary of State pulls opponents off the ballot so that incumbents can be placed back into office with no voter input. I'd like to note one additional fact. Of the 150 current members of the Texas House, 137 had 0 or 1 opponent in the general election last year. That's 91%. Texas has a problem of too few candidates, definitely not too many. Senate Bill 994, like the past filing fee bills, is trying to attack a non-existent problem. Its only real effect is to disenfranchise voters, and we urge you to oppose it. Thanks for your attention.
Thanks, sir. Members, any questions? Thank you, sir. Chair calls Wes Bowen. Mr. Bowen, you're here on behalf of yourself and your 4 SB 994, is that correct?
That's correct. I think we don't want a system where there is no penalty for not following the law, and so I think it's as simple as that. So I think the executive committee ought to be able to appoint someone in the event of, just so that the voters could have their representative or have an opportunity to vote for somebody that shares their political views as opposed to being stuck with only one candidate. So I'll turn over the rest of my time. I support 994 and request that you report it favorably to the full House.
Thank you, sir. Members, any questions? Thank you. The chair calls Thomas Burrows. Mr. Burrows, you're here on behalf of yourself and you are for SB 994, is that correct?
Yes, I'm in favor, and I think it's a wonderful country where we get to sit and discuss these things, including my wife, who has an ancestor that fought with Sam Houston at San Jacinto. And I'm in favor of this, and I pass my time.
Thank you. Thank you, Mr. Burrows. If there's no questions of Mr. Burrows, members, the chair is going to call Charles Cruz. Mr. Cruz, I show you're here on behalf of yourself and you're against SB 994. Is that all correct?
It is correct.
Go ahead.
I concur with my friend from the Libertarian Party. We need more candidates on the ballot, not fewer. That's pretty much it.
Okay. Thank you. Members, any questions? Thank you. Chair calls Linda Curtis. Ms. Curtis, I show that you're here on behalf of the League of Independent Voters of Texas and yourself, and that you're against SB 994. Is that all correct?
That is correct.
Go right ahead, ma'am.
Members and Chairman, the League of Independent Voters is a 501c4 nonprofit, nonpartisan organization dedicated to electoral competition and on behalf of 4 million or probably lots more Texans who call themselves independents, we advocate also for our minor parties. This is Senator Schwertner's bill, right?
Yes.
I know Mr. Burrows, Senator Burrows laid it out, but we believe that this is an anti-competitive bill, that this is the opposite effect of ballot crowding. The author himself is my senator, and he had the benefit also of a gerrymandered district. Since I live in the district, I can testify it was gerrymandered. And the author was opposed by Mr. Estes. Now, Mr. DiBianca stole my testimony, but I do want to point out that Mr. Estes received 3,500 more votes than Senator Schwertner received in the GOP primary. The point being made repeatedly by the Libertarian and Green parties about these filing fees is that as convention parties, they receive no benefit from these fees. It goes into the general fund. They want to continue to hold and pay for their own conventions. And I think that's a hell of a lot better than the state paying $9 to $10 million per party primary. Why don't you save the money and use it for some other purposes to help voters? Our organization believes that parties are private organizations. They should pay for their own nominating conventions or even for their own primaries. Let's all meet up in the general election and let the state pay for the general elections with instant runoff voting. Thank you for your time.
Yes, ma'am. Members, any questions? Thank you, Ms. Curtis. The chair calls Kevin Hale. Good to see you again, Mr. Hale. I show you're here on behalf of the Libertarian Party of Texas and yourself, and you're against SB 994. Is that correct?
That is correct.
You go right ahead.
Thank you, Chairman Smith, Vice Chairman Busey. Really appreciate you guys giving us the time to talk about this bill. I want to talk about some of the things I didn't say the first time around when I got to testify against this bill. I checked both my U.S. and Texas constitutions, and neither of them list a financial eligibility requirement to run for office. This bill is about removing competition from the ballot. It's a shame voters don't get to see us on the debate stage, but it's downright cowardly to fear us on the ballot. The second thing this bill does is it attempts to forego the judiciary branch and gives the power of decision-making power to the appointed Secretary of State. That alone is a conflict of interest. And for those reasons, I'm asking you to please vote no. On a personal note, I usually run for a congressional office. Working here is maybe changing my mind. However, in those elections, it's no less than 30 to 40 times during those elections, people come up to me during my sign waves. They talk to me during my 30,000 doors when I'm block walking, and they thank me. They email me, they text me, and they thank me for giving them someone to vote for. That is why you can't do this. Thank you very much.
Thank you, Mr. Hale. Members, any questions? Thank you.
Thank you, guys.
Chair calls Elizabeth Miller. Ms. Miller, I show you're here on behalf of yourself and that you're against SB 994. Is that correct?
I am. That's correct.
Go ahead.
Thanks. I know it's been a long day. Thanks for everyone for being here. I just wanted to, we don't have a lot of time, so I can't talk about all the issues with this. I just wanted to get out there what this is really about, which is this is one of the many attempts this session to get rid of minor parties. This is not about ballot crowding. You just either don't understand how this works or being disingenuous to call it that, because the Libertarian Party only gets to put one nominee on the ballot, on the general ballot. Same for other parties. So this is not about ballot crowding. This is about getting rid of the competition. And again, as I said on other efforts, and we'll say again, while I can understand the desire for sitting incumbents to minimize their competition, that doesn't make it right. So please don't do this. I'd love to discuss this and other attempts with all of you. Just give us 10 minutes to give an argument of why the people of Texas deserve choice. They want choice. Nobody wants less choice at the ballot, except for the people who are already sitting in this building, frankly. So please don't do this. Thank you.
Members, any questions? Thank you, Ms. Miller. Is there anyone else who wishes to testify on for or against SB 994? If not, the chair recognizes Chairman Burrows to close.
I close.
Thank you, Chairman. The committee substitute is withdrawn. If there's no objection, SB 994 will be left pending. The chair hears none, and SB 994 is left pending. Which one we at? Exit public 4782.
The chair lays out House Bill 4782 and recognizes Chairman Smith to explain the bill.
Thank you, Chairman. Members, HB 4782 adds conducting exit polling within 100 feet of an outside door of a polling location to the list of prohibited activities. We currently also prohibit loitering and electioneering for or against any candidate, measure, or political party. The intent of this is not to prevent exit polling. This legislation is geared towards preventing intentional or unintentional election polling that may present inaccurate representation of a candidate or ballot, which could lead to influencing or altering how someone may vote. Some concerns on the current language have been brought to my attention. I'm happy to continue dialogue to ease those concerns while staying true to the intent of the bill. Thank you for your consideration, and I've reserved my right to close.
Members, any questions? Mr. Chairman, I just have one, and you just addressed it. I want to find a compromise and support you on this. I just think that, as you just said, the exit polling definition may be a little broad, and so if we can just make sure that in a, incidental communication doesn't get anybody inadvertently in trouble, I'd like to help work with you on that.
I understand. Yeah, I appreciate that.
Thank you, Mr. Chairman.
Thank you.
The chair calls Elizabeth Barron. Elizabeth Barron, we will show Elizabeth Barron representing Texas First and Self for the bill and not testifying. The chair calls Thomas Burrows. You are, just to confirm, you are Thomas Burrows representing yourself and you are for the bill, is that correct?
Yes, I am for the bill.
Please
Yes,
proceed.
It's been a long day, and I yield the rest of my time.
Thank you, Mr. Burrows. Members, any questions? Thank you, sir. The chair calls Charles Cruz. To confirm, you are Charles Cruz, you're representing yourself, and you are neutral on the bill, is that correct?
It is.
Please proceed.
I yield the rest of my time.
All right, thanks, sir. Members, any questions? Hearing none. The chair calls Valerie DeBill. You are Valerie DeBill, you're representing yourself, and you are against the bill, is that correct?
That is correct.
Please proceed.
On the subject of the overbroad language, we've already discussed a couple of different ways that can be tightened up. I would request specifically an exclusion for election workers. The number of times I have to chase a voter out of a polling location to get them their ID back, or to stop a fleeing voter from walking away without scanning their ballot, or to get them to sign an affidavit that they forgot to sign. I'd hate to have to let them get past the 100-foot mark before I could do that. So that's my specific recommendation.
Thank you, members. Any questions? Thank you. The chair calls Emily E.B. French. You are Emily E.B. French. You are here on behalf of the Texas Civil Rights Project, and you are against the bill. Is that correct?
That's correct.
Please proceed.
Thank you. We spoke to the chair's office about some of our concerns with the language. Again, thinking any person or persons seeking to communicate with voters exiting the voting site is a little bit overbroad. For example, if I'm leaving the polling place with my husband and I talk to him on our way out, I would technically be a person seeking to communicate with a voter exiting the voting site, which would be a Class C misdemeanor. And I know communication is important in a marriage, but I don't think I'd pay a fine about it if I could avoid it. If I left my purse inside and an election worker ran out to tell me, they would technically be seeking to communicate with the voter exiting the voting site. So we just want to see a little bit of different language and make sure that innocent behaviors aren't criminalized under the current language.
Members, any questions? Thank you. The chair calls Dr. Laura Presley. You are Dr. Laura Presley, here on behalf of True Texas Elections, and you are against the bill. Is that correct?
Yes, sir.
Please proceed.
Thank you. I'm against this bill. We've had, as a candidate in Williamson County, I have had exit polling done for my campaign. We've had exit polling done for bonds and other races. And to limit a voter from talking to an exit poller, not just a local person, but also the Associated Press. You've got state and national organizations that do exit polling, and the main reason for exit polling is to double check the results. So I see this as limiting the ability to do a statistical sample of the voters coming out if you're outside the 100-foot. There's some polling locations, you can't even electioneer within that, outside that 100-foot. So I want to read a statement from a woman that does exit polling, and she's done it for probably 2 years. Actually more than that, 10 years. With the heavy doubts that many Texans have about the integrity of Texas election results, making it more difficult for exit polling volunteers to reach out and approach voters to ask if they will participate, only serves to make reaffirming poll results against the official results much less meaningful and difficult to execute and verify, no doubt severely restricting the number of likely participants. When done properly, exit polling, there is just no downside to allowing exit pollers within the 100 feet, as she has experienced many times. So I would ask you to vote against this. I see this as an anti-election integrity effort. If it's outs, you're setting up the 100-foot. Okay.
Members,
Any
any
questions? Any questions?
Thank you.
Thank you.
The chair calls Marcia Strickler.
Marcia Strickler, Williamson County.
You're Marcia Strickler here on behalf of yourself, and you are against the bill. Is that correct?
I am against the bill.
Please proceed.
Yes, sir. I'm against the bill. In my opinion, electioneering and exit polling are two very different things, and I've done both. And I don't know very many people in the state of Texas that do exit polling. Do you? I think it's important that we have the ability to do exit polling for exactly the reasons that Dr. Laura Presley just stated. Secretary of State has an advisory number 2017-14 dated October 6, 2017 that allows us to do exit polling within the 100-foot marker. I think that we as citizens need to make sure that we don't go backwards in our good laws that we have and our good systems that we have in place. And this would be one of those things that I believe would be taken away from being able to have some transparency. So I very much would appreciate you guys to consider not voting for this bill.
Members, any questions? Thank you. The chair calls Alan Vera. You're Alan Vera, here on behalf of the Harris County Republican Party Ballot Security Committee, and you are for the bill. Is that correct?
Correct, Mr.
Please
Chair.
proceed.
During elections, the Harris County Republican Party and the Republican Party of Texas have toll-free hotlines for voters, campaign workers, and election workers to report problems they're seeing at the polling places. In terms of sheer number, complaints about illegal electioneering inside the 100-foot line are the most frequently reported complaints. Whenever we've succeeded in getting a county election official to actually travel to the polling site to investigate, the folks they catch inside the 100-foot line always use the excuse that they're doing exit polls. It's become apparent to us that, at least in most of the cases we've faced, the exit poll claim is just a loophole being used by electioneers to violate the prohibitions in TEC 61.003. This bill will help reduce the contention and chaos that too frequently characterize the activity outside of polling places, and will help eliminate a major distraction for the election judges who already have their hands full inside the polls. With proper corrected language, the bill's a common sense change that's overdue. We ask you to move the bill forward. Thank you.
Members, any questions? Thank you, sir. Chair calls Susanna Carranza. Dr. Susanna Carranza. You're Dr. Susanna Carranza. You're here on behalf of yourself, and you are against the bill. Is that correct?
Yes, I actually just came from being an election worker, deputy at UT, and with that definition of exit polling, like half of the student population at UT would be considered that, because it's a public place. There are people voting with their friends, and sometimes there are their friends, oh, you just voted, what happened? So it opens the door that if somebody's trying to really intimidate people, they kind of say like, oh, you can't have this conversation. And any polling place that is a highly public place would have a hard time enforcing this bill with the very broad definition, and it would be catastrophic in some areas. Thank you.
Members, any questions? Thank you. Oh, yeah. Representative Morales.
Sorry, I showed up, thank you, Mr. Chairman. I'm reading the bill, and it provides that no electioneering or lawyering can take place within that 100 feet radius that is already out there, that even candidates cannot cross.
Yeah.
Or our own staff or volunteers. So this would only apply, the way I'm reading it, to any sort of exit polling cannot take place within that 100 feet mark inside.
Yeah, but the definition of election polling on the item, I forgot the item number, but it's on the second page of the bill. It's so broad because it says any person attempting to communicate with a voter as they're exiting in a place like in grocery stores, any place that you have heavy traffic, it's like, it's too broad.
Doc, I think we got it, and we're looking at the offer,
Yeah,
and I think that they may come up with something that may.
Yeah, but include not just family, but there's like, friends voting
Let's
together.
say we modify the definition to meet the actual issue of what exit polling does.
Yeah, then I'm neutral.
And
on
it's
that.
only within the 100 feet. So as long as they go past the 100 feet, then anyone, TVs, exit polling, experts, individuals, anyone could then ask any sort of questions you're comfortable with, as long as it's past the 100 feet.
Yeah, but the whole concern is the language has to be really tight because in a public place, a lot of people have conversations within the 100 feet, and it's impossible to block. No place would agree to become a polling place if you would have to essentially block any conversations. So that's my concern. I just came there, so I just witnessed that today. And
Understood. Thank you, Doctor. I appreciate it.
Thank you.
Members, any other questions? Thank you. The chair calls Robert Green. Robert Green, we will show Robert Green representing the Travis County Republican Party Election Integrity Committee for Legislation and itself for the bill, not testifying. Katia Ersman. Now I messed it up. Yes, I'm not having more. You're Katia Ersman with Common Cause Texas and yourself, and you are against the bill, is that correct?
Yeah. Thanks.
Please proceed.
We'll try to keep this really quick. One thing that we wanted to bring up, in addition to the concern of poll workers potentially coming into that 100-foot line and trying to talk to a voter because of the broad definition of exit polling in the second section, is that Common Cause helps lead the volunteer and field program for the Nonpartisan National Election Protection Program, which places hundreds of trained nonpartisan poll monitors across the state. We receive tens of thousands of calls into our election protection hotline, and we help voters at polling locations dealing with problems or having questions. Unfortunately, many of our poll monitors, while they're instructed to stay outside of the 100-foot line, have a concern with navigating the placement of those cones being not a complete science. Many of those cones are placed, but they're not sure, if it's exactly 100 feet. And so I think we've already talked to the chairman's office about some more strict language about what that, definition of exit polling means to, restrict the communication with voters coming out of the polling location, to be more specific as to using things like Montana's definition, which is specific to when asking a voter intentionally whether or not they voted for a candidate or a ballot measure. The other concern that we have is based off of precedent from federal lawsuits, like one coming out of New Jersey that sets press as a protected speech when asking about polling locations. So given that kind of First Amendment concern that's already been laid out in federal courts, we just currently oppose the bill as written. But again, I've been working with the author on some different changes.
Members, any questions? Thank you.
Thanks.
The chair calls Christina Atkins. You're Christina Atkins. I notice your title says Director of Elections, and you are here on behalf of the Texas Secretary of State, and you are neutral on the bill. Is that all correct?
Yes, sir.
Members, any questions? Do you have anything to share?
No, sir.
Thank you.
Thank you.
Thanks so much. Is there anyone else wishing to testify on, for, or against House Bill 4782? Yes. Yep, come on. Did you pre-register?
I did. I thought I'd signed up to testify.
What is your last name, sir?
Bowen?
Owen?
Bowen with a B.
Let's see you in there. Kia can help you get registered on the iPad because it's not showing you in there.
If you step right over here. so
Sure.
I can get yours.
Thank you.
The chair, one second. The chair calls Wes Bowen. You are Wes Bowen. You're here on behalf of yourself, and you are for the bill. Is that correct?
That's correct.
Please proceed.
Yeah, I am in favor of HB 4782. I'm also the chair of the Dallas County Republican Party Election Integrity Committee. We haven't taken a vote on this, so I'm not absolutely representing
So
that
just
committee.
confirm.
I'm representing myself.
You're representing yourself. Thank you. Please.
Yep, and so I think it's not that confusing, actually. So electioneering is not having a conversation with your spouse leaving the voting place. Electioneering is advocating for a measure or someone on the ballot inside a voting location. And so I think there's so much electioneering that goes on in Dallas County that gets reported to me that we need to make it more clear about the protection of the 100-foot marker and not make it confusing in any way. So my opinion is, maybe the first time I've ever disagreed with Dr. Laura Presley, but I actually believe that you should be outside the 100-foot marker before you're doing the exit polling. And my comment about other activity within there, I think you need to reconsider if it's a proper voting location, if you can't control the voting location, which includes the 100-foot marker. That's all I've got.
Members, any questions? Thanks, sir.
Thanks.
Is there anyone else who wishes to testify on, for, or against House Bill 4782? Hearing none, the chair recognizes Representative Smith to close on House Bill 4782.
Well, we're obviously not trying to do away with exit polling, and believe it or not, this may be a first, but I agree with Susana Carranza. And Ms. Arisman at the same time. And we'll work on that definition. It is too broad. The definition on that is too broad.
Mr. Chairman, did your wife ask for you to not be able to speak to her within 100 feet?
Yes.
Members, any questions? Thank you, Representative. If there is no objection, the House Bill 4782 will be left pending. Is there objection? The chair hears none, and House Bill 4782 is left pending.
Pull you up, 761.
The chair lays out Senate Bill 1661 and recognizes Chairman Smith to explain the bill.
Thank you. SB 1661 prohibits an authority operating a central counting station from purchasing or using a ballot scanner unless that scanner is only capable of using a storage device such as a thumb drive that cannot be modified without automatically detecting that there has been a modification and then rejecting the vote record on the device. This would provide an additional measure of security and ensure that the data storage device can't be overridden or have the vote data changed once the data is initially entered. Under this system, if a device is tampered with or modified and the votes on the drive cannot be counted, the paper ballots will be the vote record for that counting scan system. This was what we intended to do last session in SB 1, but there has been some misunderstanding of the scope. SB 1661 seeks to clarify that this is limited to the storage device only. Thank you for your consideration, and I reserve the right to close.
Members, are there any questions?
I do, Mr. Chairman.
Representative Morales.
Yes, sir.
Representative Smith, Can you tell us a little bit more, what exactly was the problem that is trying to be fixed?
Well, I think what we're wanting to make sure is that with this particular, like here, it says that the purchasing or using a ballot scanner, unless that scanner is only capable of using a storage device such as a thumb drive that can be modified without automatically detecting that there's been a modification, and then rejecting the vote record on the device.
But is it because we had issues with USBs being used that you couldn't tell if they were modified?
So I'm not sure what the backstory is on Senator Hughes's bill, which this is, but I can get you that information.
Thank you.
Yes.
Members, any other questions? We'll reserve your right to close. The chair calls Christine Atkins.
Do you know? We should have started there, sorry.
You are Christina Atkins. You're here on behalf of the Texas Secretary of State, and you are neutral on the bill.
Yes, sir.
If that's all correct. Members, any questions? Representative Morales?
Thank you, Mr. Chair. And I'm sorry, Representative Smith, but I should have asked our resource witness. Yes. Can you tell us what problem we're trying to solve?
Yes, sir. So this particular provision, the reason why it's being modified is because in Senate Bill 1 from 2021, this provision was added to the election code. The language was written in a way that would have required voting systems, our electronic voting systems, to be replaced statewide. It was written in a way that was just a little bit too specific, that there are no current systems today that can do what was required based on the language that was written there before. So my understanding is that Senator Hughes worked with interested parties in this to ensure that it was modified in a way that was not invalidating or making the current equipment that's in use not usable anymore, but also done in a way to expand some of the security features there and expand some of those protections. The way it was written before is it was limited to just scanners that are used in the central count, so like central scanners. This is actually broadening it to make sure that this like higher level of security is in place for all scanners used in elections, even those in a polling place. So it was fixing the limit, the overly broad language, but also expanding the protections.
And understanding then that with the change, we're not going to be asking every county to change their...
Correct. Yes, sir.
Their machines, their equipment.
Yes, sir. That's correct.
Do you know if the use of these specific USB drives are considerably priced higher than a regular USB drive because it needs to track whether there were any modifications?
Yes, sir. They are more expensive, and that's because they're all proprietary. They're not just off-the-shelf thumb drives. All of the thumb drives that are used with the electronic voting systems today have a proprietary component to it based on the software that's being used. And that's a security measure that's in place so that you can't just go get any thumb drive and use it in an election. It has to be one that's able to be used with the software that was certified for the voting system.
But, and I like the bill, and I like the fact that we can have a checks and balances, but I would like just to get an idea of what are we talking about? Are we talking about you going from a $5 USB to now a $500 USB, or is it more somewhere in the middle?
It's somewhere in the middle. It's the safest way to answer that. But this is actually, the systems that are currently certified today already have these security protections in place. And so the thumb drives that are in use with the systems today are still usable.
So it's not like our counties are going to have to go out there and buy new USB.
That's correct. As the bill is written, it does not require that. But I will say, I just always want to clarify this, but it does expand the requirements, the protections to all of our scanners. And so it's putting that higher level of security on more equipment. But again, it's not going to require that anybody purchase anything that they haven't already purchased.
Now, what about the county that doesn't have scanners, as I've mentioned in previous hearings, where a number of my counties still use the paper ballot?
Yes, sir. So that's a separate requirement in the election code, right? So if you want to have an electronic voting system to help count your ballots, so not just for accessibility or ADA purposes, but those have to be certified through both the state and the federal government. The systems that are in use in Texas that are currently certified do what this bill is requiring already.
Okay. And this bill also, or you have wording that addresses the Remember how last meeting we were talking about preservation and the chain of custody of machines and the ballots also? Will USB drives also, are they included as part of that chain?
Yes, yes, sir. In fact, there's a specific provision in the election code. It's 129.051, I think is what it is. Yeah, 129.051, that specifically talks about chain of custody and security procedures related to electronic voting systems. It's got a specific subsection that talks about the electronic media, maintaining chain of custody and inventorying the electronic media used with this equipment.
Thank you.
Yes, sir.
Ms. Atkins, you just said it, but just to be very clear, the data storage devices manufactured by ES&S and Hardit InterCivic that are currently used in Texas counties comply with these requirements in this bill, correct?
That's correct. Yes, sir.
Members, any other questions? Thank you. Chair calls Charles Cruz. You are Charles Cruz. You're here on behalf of yourself, and you're against the bill. Is that correct?
I was this morning. I am changing to neutral on the bill.
Just 1 second. We'll get you to change. You give us your permission to change from against to neutral on the bill.
Correct.
All right. 1 second. All right. Please proceed.
I yield my time.
Thank you, sir. Members, any questions? Hearing none. The chair calls Wes Bowen. You are Wes Bowen. You're here on behalf of yourself, and you are for the bill. Is that correct?
That is correct.
Please proceed.
Yeah, so SB 1661 is a good start, but I actually think the bill needs some work based on what Ms. Atkins just said, because if it talks about these are ballots that are scanned in a central counting station, then the overwhelming majority of the ballots scanned in an election would not be scanned in a central counting station. They would be scanned by the tabulators out in the voting locations. So to get a really good election integrity bill, you would want all scanned ballots in the election to be on a non-erasable device. And I don't understand that after the CVR is written, after the cast vote records, because I don't think there's anything in the code about when that needs to be written. So at this point, it's really unclear in terms of what you really accomplished from my perspective. And the reason I take this position, and the reason why I think that we do need to have some reliable, examinable USB drives is because of some things that have happened in Dallas County in 2022 when a large number of our DS200s failed and they had to replace the heads on them. I think all of those should have been, forensically examined in 2020. And at the end of early voting, watchers in the Central Counting Station in Dallas County noticed that the UP Methodist and the El Centro USB drives were switched and they were in the wrong bags. Those would have been under more scrutiny. For someone that was challenging the election to look at a thumb drive that could be erased and rewritten over it, I don't think that really accomplishes anything. So this would be a big step in the right direction. I also don't believe that the thumb drives that Dallas County is using from the ES&S system, I think those are reusable, frankly, so I would ask for some research to be done on that.
Members, any questions? Thank you, sir. The chair calls Elizabeth Barron. Elizabeth Barron, we will show Elizabeth Barron here on behalf of Texas First and Cell for the bill, not testifying. The chair calls Thomas Burrows. You are Thomas Burrows here on behalf of yourself, and you are for the bill. Is that correct?
Yes, with reservations.
But you, just to make sure we've got the record correct, you're for the bill.
It, but with reservations.
You're for, on, or against?
I'm for.
And then you can proceed.
Okay. I've heard this representative use USB. I've heard this representative use thumb drive. I'm an IT professional. We have a joke about, what the analyst wanted, what the designer wanted, and whatever else, and what the user wanted was a swing under a tree and not a cut down tree, et cetera. There's all this stuff going on. I mean, thumb drives, USB drives, are they writable, rewritable? I mean, none of this is defined here. And this is, trust me, I can hack into anything if I give me enough time. And also, what exactly is a cast vote record? What does that include? Does that include Representative Manuel and Representative Morales, but not Representative Busey in a record of who's here today? You know, I mean, there's none of this is defined, and then you're kind of like bailing off of what the madam from Secretary of State is saying. You know, I don't hear anybody with the real IT stuff behind this, but that's just my opinion. Trust me, somebody can hack into this stuff and change this with the loose rules you guys have.
Members, any questions? Thanks, sir.
I just want to make...
Representative Morales.
The bill uses the words data transfer media device. Is that more helpful to you?
Well,
rather than
why are you guys using thumb drives and USB and stuff when it says data transfer media device?
Oh, my apologies.
Well, I'm not harassing you. I'm just, you know.
Yeah, no, and it's, you're right. We should be wordsmiths, and as an attorney, you are correct. It's been a long day. We've been on the House floor, and my apologies, because I should have used the exact wording that was there.
My wife's a lawyer too. It's interesting.
I'm sorry to hear that.
She makes a lot of money and lets me go play politics.
My wife is here, and she would agree with you that it's difficult to...
Members, any other questions? Thanks, sir.
Thank you.
The chair calls Robert Green. Robert Green, we will show Robert Green on behalf of the Travis County Republican Party Election Integrity Committee for legislation itself for the bill, not testifying. Dr. Laura Presley. You are Dr. Laura Presley on behalf of True Texas Elections, and you are for the bill. Is that correct?
Yes.
Please proceed.
Thank you. So I agree with what Wes Bowen said. This bill is focused on changing the central counting station part of the code, not the polling location part of the code. So this strictly deals with scanners at the central count station, which does absentee ballot scanning most of the time, probably 99% of the time. Absentee ballots are 5 to 8% of the total vote around the state. The other 92% of the ballots are cast at the polls, scanned at the polls on the DS200, for example, ES&S, and this bill does not address that. This bill only goes to the central counting station. If you want to make this bill effective to the ballot scanners at the polls, you're going to have to change another section of the code that deals with the certification. And we made this recommendation in the Senate, and I think it just somehow missed the boat here. You'd have to change section 122.001, voting system standards. I would love what Mrs. Atkins said to be true, that this is intentionally supposed to be also those ballot scanners at the polls, because we need it at the 92% level also. The other problem is that it only references that the cast vote record can't be changed. You've got other data on that media device: ballot images, audit logs, metadata, time and date stamps. You have zero tapes and result tapes. All of that data is on that memory stick, on that media, and this bill says just make sure the cast vote record's not changed. What are we thinking? None of it should be changed. So I'd be happy to work with Representative Smith on, shoring this up to what Ms. Atkins thinks it should be. And I know that Senator Hughes would be very happy with that.
Members, any questions?
Any questions?
Thank you.
Thank you.
The chair calls Marcia Strickler. You are Marcia Strickler here on behalf of yourself. You're for the bill. Is that all correct?
I'm for the bill. I am. I testified for it in the Senate committee as well. I do believe that it's the intention of the bill is to have more security on our elections. I do believe that that is the intent. There is a lot of room for ambiguity here, and I think that it does need to be shored up. I don't necessarily need to repeat what Dr. Laura Presley or Wes said earlier, but this protection primarily does affect the absentee ballot. So if, as a former poll worker, poll watcher, and election employee in the field, the thumb drive or the device itself is in the DS200 or in the machine that scans your ballot at the polls. And the judge takes that out at the end of election and takes it to central count. That central count team takes that thumb drive and will then put it into the DS850 or whatever it is that the systems have at their central count in each county, okay? And so technically, that thumb drive would then become a central count piece of equipment, but the way this bill reads, it does not really cover that. So I do believe that right now, the way it reads, it primarily protects the ballots that are scanned at central count that come in through the mail-in ballots. And 90% of our ballots don't come that way. And so if we're truly trying to protect our ballot system and our integrity of our ballot elections, then we need to have this technology also at every polling location that we have equipment in that are scanning ballots. Thank you.
Members, any questions? Thank you. The chair calls Alan Vera. You are Alan Vera, here on behalf of the Harris County Republican Party Ballot Security Committee, and you are for the bill. Is that correct?
All correct, sir.
Please proceed.
This bill is a great idea. The origin was to fix some bad language in an amendment in last session to Senate Bill 1, which would have basically ruled out all the current election equipment we have in use in Texas. That was the reason. The bill's trying to do some good things here, but there's a disconnect. The bill is written about central counting station and specifically scanners in central counting station. The only ballots that get scanned in central counting are mail ballots and any ballots that were rejected by the scanners in the field that could not be scanned at the polling place. They're brought back to central count. Everything else is scanned at the polling place. And that's not addressed by the section of code being discussed here or by the language. So I think it's a good idea. I think there's a good intention here. I think the specifications are good. The committee may want to tweak this to ensure the bill's doing what you want it to do before it goes to the full House. Thank you.
Mr. Vera, just confirm you are for the bill.
Yes, I am.
Members, any questions? Representative Morales.
Mr. Vetta, so based on Mrs. Strickler and Dr. Presley's comments also, there's a USB drive during the early voting stages, right? But that never gets counted until at the end of the early vote and during election day, all those, let me get this right.
Thank you for that question, because
All those transfer media devices are.
yes,
Central.
and the cast vote record is the record of the vote you cast, and I cast. It's in that media transfer device.
Correct.
And it's by itself until election day, when it's loaded into a tabulator, and the tabulator takes the information from that and reports the results.
So we've got to make sure that on the bill, we are also making it very clear that during the early vote, the USB or the transfer media devices that are being used at each one of the scanners there has the same protections and has the same safety features as the ones that we are pointing out here for the central county station.
That would make this bill even better.
Okay. And that way then they're not tweaked, they're not modified in any way, and if they are, there's a way that we can see that they were tampered with.
Yes, sir.
But they are supposed to then go from there to the central counting station, and then we do your
Tabulation, yes, sir.
tabulations. Perfect.
Perfect.
Thank you.
Members, any other questions? Members, we have our resource witness is still here. If anyone had any clarifying questions based on testimony, does anyone want to hear from our resource witness again? The chair calls Christina Atkins. Back up. Just to confirm, you're Christina Atkins here on behalf of the Texas Secretary of State, and you are on the bill.
Yes, sir.
All right, Please proceed. Members, any questions? Representative Morales.
Thank you, Mr. Chair. You heard the
Yes, sir.
concerns expressed by some of those that testified. I also have those same concerns because I think the wording is maybe not that clear.
Well-
Can you provide some guidance, or can we make sure that we are talking about those transfer media devices that are being
Yes, sir.
used during the early vote?
Yes, sir. I do read it to be that broad, and if you allow me, I'll walk you through exactly why I think that. So what this subsection says is an authority operating a central count may only purchase or use a ballot scan system. So it's not talking about the use of the system in central count. It's saying the authority that operates a central counting station. All of our larger counties that use these systems where they have ballots that are read out in a polling location, or ballots that are scanned in a polling location, that data is read to the thumb drive or the transfer media device. Those transfer media devices are then taken back to the central counting station, where they are inserted into a computer that accumulates and aggregates those vote totals. That's part of the central scan system. So the scanners out in the field, the thumb drives that are used there, that are later read into the central computer that's used for aggregating those totals, all part of the same system.
Got it.
So I believe that this does apply to any of those thumb drives that are used as part of that central count system, including those that are used out in the field. That's how I read this. I think when you strike through centrally counted optical, that phrase right before ballot scan system, and it's just broadly referring to the ballot scan system, it covers everything.
Got it.
That's why I see this as an expansion.
I love it. I thank you. I now thank you for making that clear. An authority operating, just operating, doesn't matter where, operating a central counting station may only purchase or use a ballot scan system
That meets these requirements.
at the early vote. In the early
Period. I
vote
think
location.
period. I think period. No matter what, they can only purchase a system that meets these requirements regardless of where they're using it.
But their ballot scan system, either at the early vote location or at the central counting location, has to meet all of these
Yes, sir. Yes. Early voting, election day, central count. So we're talking in person and mail ballots as well.
Okay, now what about the concern about that we only are saying do not tweak that it needs to address the detection or modification and the rejection of the cast vote record, and does not allow for the process under this subdivision to be overwritten or circumvented? What about the testimony of the metadata and all this other information? Can we be more inclusive or a little bit more broad that none of the metadata that is contained within those transfer media devices should be tweaked or messed with in any way?
Well, I think in practice what happens with these devices, I say I think, I know what happens with these devices because we certify these systems. So what happens, and I think I can explain to you how it works with each of the different vendors. With ES&S, those thumb drives are encrypted. So they have a pretty high level of security on them. With the HART system, they're digitally signed. And so what I think this language is getting at is that if there were some kind of modification or attempt at modification, there would be a way of detecting it, is broadly what this is saying. And I know that both vendors actually sat at the table to make sure that they were, that the language that was used here was doable, and we were not creating something that was going to make systems unusable. And so this is allowing for a way of being able to identify if somebody attempted to alter data that's on that device. I think I do understand the point that some of the individuals are testifying or making, and that it's written a little bit, maybe a little bit specific. I think there's ways that could have been written a little bit more broadly, but I still think that this is getting to the intention of what we're trying to do here. And we're trying to say that if the information or data on these devices has been altered or modified, or an attempt has been made, that you can't use them. I mean, that you don't want to use that data transfer device anymore. We're trying to put some kind of protections in place so that it can't be modified and can't be read into those systems. And I think this is what I read here, it's doing that.
It's doable even, and that would encompass, what we have right here, and would encompass also all of the metadata?
You're asking me a question that's maybe a little bit more technical that I can answer right now, but I can definitely talk to some folks to get you the right answer on that.
Can you, please?
Yes, sir.
Because if it's necessary, maybe I'm seeing under subsection 1A, right, the detection of the modification of metadata. maybe that's where we can.
And I'm happy to talk to some more technical folks, some of the folks that advise us on the voting system exams to discuss that concern with them and see if they think this language covers that. I also just want to point out one other thing that's really important to note with electronic voting systems is the data that's on these transfer media devices, that's a record of the votes that were cast. But if there's ever a question in an election as to the accuracy or integrity of the data on that device, if we believe it's been altered or modified in any way, your ballot of record is your paper ballot. And you can always go back to that ballot of record and not use the information on that device itself. There are mechanisms within the code if we think that there have been alterations or attempted tampering or problems with the electronic version of those votes cast, then you have the paper ballot that you can go back to count.
Okay.
So,
And are you aware of the Secretary of State having to do away with the transfer media device and go to the paper ballot in the past?
I am aware of situations in which there were problems with the transfer media devices, not necessarily evidence of any kind of tampering or malfeasance or bad actions, but problems with the device itself not being readable for one reason or another. And in that case, we direct them. There's code provisions that would dictate this. You go back to the paper ballots and you count those paper ballots. And there's a mechanism for doing that either electronically at your central counting station, or in some situations, if you have to, hand counting is a viable option.
Got it. Perfect. Thank you.
Members, any other questions? Yep, Representative Manuel.
Just have another quick question with my novice cybersecurity understanding. Also, isn't every time one of these thumb drives, flash drives, whatever you want, hard drives, all of the different sources, isn't there a record of every time it's plugged into that machine, to the machine that it's plugged into, or to the voting machine?
All of our voting devices, so the central computer where everything's aggregated, the devices that are used where people mark their ballots, and then the devices where people scan their ballots, so the scanners that actually tabulate. They all have internal audit logs. Those audit logs are election records. Anybody can request them. They are publicly available records. And I know many of the folks in this room actually do routinely look at audit logs.
And isn't that, because I also want to really fast touch on, you were saying that for some reason, like if a machine malfunctions, whether it be the machine itself or it's the flash drive, thumb drive, any of those situations, that if that throws off a lot of times, and this is me seeing this, reading some of this stuff, doesn't it also sometimes shut that machine down to make sure that it's
Yes.
whatever the malfunction is, so that people aren't voting on a machine that is not properly?
That is a possible outcome depending on the type of malfunction or problem that happens. I'm sorry, it can happen in certain cases. The other thing that I think is always really important to remember, that when we're talking about security of our electronic voting systems, security, it's a holistic concept. It's not just about the security on that one device or on that one piece of hardware. We're looking at the big picture, and that's why chain of custody procedures are important. That's why poll watcher access to records are important. That's why transparency in the entire process, being able to see where your ballots are at all times, during the transfer process, that all feeds into the security here. So we have to remember that while we want to make the components as secure as possible, we have to remember that it's not just that one piece that makes the system secure. It's the process, and it's all of the protections that are there.
And then lastly, I just kind of want to reiterate, because you've said this before, I've asked this question. Whenever, granted, we don't always have a new elections 2.0 system every year,
Yes,
but if memory is stating correct, the cybersecurity part of it is consistently always being updated, always being checked upon. It's not like we wait every 6 years to make sure that our cybersecurity is up to date.
Yes, sir. I would say that the devices, the hardware that you use, doesn't change as frequently as the software does. Our vendors are constantly in development to tweak and modify and make our systems more secure. There's always something going through the federal certification process and through the state certification process more frequently. It used to be that there were more years that would pass between certifications. Now we do them every year, sometimes multiple times a year. because they are constantly making updates on the software to make it more secure and to make it more accessible.
Perfect. Thank you so much.
Yes, sir.
Members, any other questions? Thank you. Is there anyone else who wishes to testify on, for, or against Senate Bill 1661? If not, the chair recognizes Representative Smith to close on Senate Bill 1661.
Well, all this technical jargon just gets me all kinds of flustered. But I'm glad that we had our resource witness here to be able to kind of help us out with that. Now, I'm going to get back with her, Representative Morales, and make sure that we have this thing buttoned up like it needs to be, and I'll do so quickly. But I appreciate y'all, and I close.
Thank you, Representative. Members, any questions? If there is no objection, Senate Bill 1661 will be left pending. Is there objection? The chair hears none, and Senate Bill 1661 is left pending.
The chair lays out Senate Bill 1750 and recognizes Representative Kane to explain the bill. Chairman Kane.
Chairman Smith, Vice Chair Busey, and committee members. Normally I have really short layouts, but I'm going to go through this full one. In 2020, shortly after the November election, Harris County changed the leadership of the elections operations from the elected office of the Harris County Clerk and the Tax Assessor Collector to an appointed position of the Elections Administrator. However, the subsequent administrators appointed had little to no experience with tax election laws and have overseen multiple election disasters, including equipment malfunctions and incorrect ballots. The first elections administrator appointed has a little over 5 months of experience in administrating elections for the second largest election entity in the nation. After her resignation, she was replaced by someone who had zero experience with the Texas election laws and no experience with Harris County, moving from Washington, D.C. to Houston only 3 months before the second largest election in the country. Since the implementation of NEA, each election's been a disaster in Harris County. Each election results with more votes than voters, malfunctioning equipment, inadequate training, counter-effective election worker replacement, poor polling place acquisition, incorrect ballots, poorly maintained voter rolls, and more. Yet Harris County leadership has done nothing to remedy this embarrassingly poor quality of operation of the election department. I believe it's time the Harris County elections to return the accountability of elected officials, the Harris County Clerk and the Harris County Tax Assessor Collector. Yes, two people that are on opposite parties of mine, but I believe because of who they are, because they're elected, they'll be more accountable to the voters. In fact, one of those reasons the bill relates to Harris County only is that Senator Betancourt's office conducted a survey of other large counties in Texas and found that while each of those counties encountered problems, the problems were recognized and they were addressed. But not Harris County, though. Each election seems to bring a new and bigger disaster than the last. Elected officials are in the public. They make public appearances and are much more available to the voters than the administrators. Therefore, this proposal aims to restore accountability to elected officials and provide more experience overseeing the critical task of election operations. The bill would abolish the role of election administrator in the counties with a population of over 3.5 million. The county clerk would assume the role of election administrator, and the tax assessor collector would assume the role of voter registrar. With that, members, if you'd like to bring me back up after for some questions, if you have witnesses, I'd be happy to do so. Then I'm finished with my layout.
Thank you. Members, any questions? Vice Chair Busey.
Thank you, Mr. Chairman. Chairman Kane, I think there was a version, I know this is Betancourt's bill, Senator Betancourt's bill, but at one point it was $1 million threshold. I think it's been changed to $3.5 million. Was there a reason for that change?
Yeah. So my bill is filed, it only was for Harris County, but this was a committee substitute in the Senate. Look, after they talked to all the other counties, those large counties, They found that they didn't have the problems Harris County did. They had problems, they corrected them very efficiently. They haven't had the kind of the constant issues, and so for that reason, they decided to settle it only on the county that seems not to be able to get their act together.
Who did that survey?
Betancourt's office.
Senator Betancourt's office. I've heard about some issues in the November election in Bell County. Just curious what the feedback was there, where court had to step in to keep elections open. 20% of Election Day polling places require a court order to keep the polling place open late in November. Did we get feedback from that county?
Is that for Bell County?
Yeah.
I'm not aware, but maybe the Secretary of State's office might have answers for that.
So just to be clear, and I think you said it pretty clearly, this is just for Harris County. This is no other counties in the state.
It's for any county over 3.5 million. Currently, that's Harris County.
Just Harris County. All right. Thank you, Mr. Chairman.
Thank you.
Members, any questions? Okay, thank you. The chair calls Christina Atkins. You are Christina Atkins. You're here on behalf of the Texas Secretary of State's office, and you're neutral on this bill. Is that correct?
Yes, sir.
Do you have any comments prepared or that you want to make concerning this bill?
No, sir.
Okay. Members, do we have any questions of our resource witness, Representative Morales?
Does the bill provide, in addition to being an elected official, does the bill provide for any sort of requisite background or experience in the in this field of election?
No, sir.
So technically, we could end up with the same exact problem that we currently have, or that was described.
I suppose that's possible. Yes, sir.
Okay. What is your understanding, or what is the percentage of folks that within the state of Texas that actually use an elections administrator?
I believe it's a little less than half of our counties, or right around that halfway mark, that have an elections administrator. The alternative is that those, in the other counties, those election duties and voter registration duties remain with the elected officials, by which that's the default. Texas law, by default, provides that elections are run by your county clerk and your voter registration activities are with your tax assessor collector. So many counties have opted not to move to an elections administrator.
How long have you been working with the Secretary of State?
Almost 11 years.
Okay. And in those 11 years, have you had to deal with issues related to Harris County elections?
Yes, sir.
Okay. And in dealing with those elections, do you believe that by virtue of just having an elected official that's basically based on a popularity contest, that suffices to address the core issues that have been the central focus not only of this committee, but I think of many news articles? Is that alone, just having a popularity contest and getting that person up there to do the work?
I understand what you're asking. That's a hard question to answer, and I think it's a little bit more nuanced than that. I think that Harris County is always going to have challenges based on population and geography. It's a large county. And there's always going to be, resource concerns. I know that I have been told that, when they converted to an elections administrator office, that there were some challenges. I think very publicly, the elections administrator acknowledged some of the challenges in converting based on not having access to as many resources as they would have had when they were under the county clerk's office. And beyond that, I can't really speak to a whole lot of details because I have some anecdotal experience in dealing with Harris County. I know there have been a large series of complaints that were filed with respect to Harris County. There's a number of election contests that are pending. And at some point here, our office is also conducting an audit of the 2022 election in Harris County, but I have not been able to review that data myself at this time.
In a perfect world, and if we were to go down this route of using a county clerk, what additional, based on your experience in the 11 years and based on the concerns that you've seen and the complaints that have been lodged with respect to Harris County elections, what would you like to see in an individual that would be running an election in a place like Harris County? what type of background, what type of experience, and should we include that in this bill?
That's an interesting question. I think when we're talking about our larger elections, there's a couple of things that are really critical for our elections administrator or the folks that are running elections. I think even those offices where they have an elected official that's running elections, oftentimes they're hiring or bringing in individuals to help with the election process itself. And there's really two key pieces that I think are very critical that we don't talk enough about with elections. One, our elections officials have to be very good at logistics. They have to be logistics managers. I mean, it's a massive operation that they're running, and there's a lot of moving pieces, and so they do have to understand how those pieces work together. I think managing technology in a polling place and in an election process is also important. So understanding that on some level they are managing, an IT infrastructure is very important. I think also having a knowledge and understanding of our laws in Texas, it's important. Those are some broad categories that I think having an understanding of those areas are the things that I think oftentimes set, certain election administrators apart. Their willingness to learn and engage in those areas or bring in individuals that have the expertise in that area to support them.
I'm just noting some of the issues here. You probably need a Fortune 500 CEO that understands the dynamics of having to take care of so many volunteer or assistants under you, right?
I think for our larger counties, there's usually an entire team of individuals, that provide leadership in the elections department.
You probably need someone such as with experience of an air traffic controller, where everything's hitting you at once, right? With all the complaints coming in, the calls, these different ballot locations, either missing paper or needing more stuff or having some irate, person there that wants to vote and there's issues. You need somebody with like a UPS, FedEx, logistics type experience, training, understanding how to get their employees from one location to another to address some of the concerns. Mm-hmm. And also somebody that's probably has legal experience, a lawyer, understands election law, forwards and backwards. I venture to say that I think it's very hard to find someone that would have all of that requisite background. And then we're dealing with a county that is many times bigger than a number of U.S. states as far as total population. And so considering all of that, where do you think this falls in terms of, I mean, it's bigger than God knows how many U.S. states, just Harris County alone. Where do you think this falls in terms of the issues? Now, when we compare it to that degree, are the issues this big in relation to comparing it to another state? Or are they so extensive and numerous in the complaints that bad that it requires us to make all these changes? Because it almost feels like many times we're here just having to deal with complaints and concerns over Harris County.
Yes, sir. I think that's a hard comparison to make because we do have states that run elections from the top down. And so there are large states that have a top-down model where the state controls everything in the election process. They dictate the equipment, they write the procedures, they manage the programming of the ballots. And so I think, there are models out there where you can look at large states that successfully do that. And so that's just a different way of running elections. But I think large-scale operations, running them on a large scale, that there are states that do that, so that there are models out there where they can be successful. I think with the situation we're in now, I think there are some fair questions that are being asked right now. In the last couple of elections in Harris County, I think it's very publicly known that there have been some issues, that there have been some problems and some hurdles. And I mean, I'm not saying anything that's not already in the newspaper there. I think that's well known, and I think that's why we're having the discussion, and that's why these bills were filed, because there has been a pattern of problems repeatedly in large elections that have the potential to be harmful to voters.
But where do they fall in line of comparing it to other states when you're actually comparing that somebody like Harris County is so big that it's bigger than a good number of U.S. states? And if you don't have an opinion,
I-
let me know. You don't have an
I think that I'm not going to have an opinion on that at the moment. I think I think I have to. My job here is to be a resource
you.
on the law and to
I don't want to
speak
put you in a situation. Last question,
Yes,
Mr.
sir.
Chairman. Between an elections administrator and a county clerk, what's been your experience as far as understanding who has the requisite knowledge, background, experience to be able to conduct an election such as this for Harris County?
There are some excellent county clerks out there that are elected and that take that job very seriously. And so I don't think that necessarily I can quantifiably say one is better than the other, just looking at the numbers of officials that are out there. It depends on the individual. And we have some excellent county clerks that do an amazing job running elections, in addition to running the courts, doing probate work, managing the records of the county, where elections is one piece of what they do. And I think, we have to acknowledge that some people do that quite well, even wearing all those other hats.
Thank you.
Yes, sir.
Thank you, sir. Vice Chair Busey.
Thank you, Mr. Chairman. Just a few quick questions. One, can you talk about, because as part of this layout, we talked about going back to people that are elected. Can you talk about how the EA is picked in a county?
Yes, sir. So this is actually defined in the election code. So right now, by law, the default situation is that elections are with the county clerk. Voter registration activities are with the tax assessor collector. It's subchapter B, chapter 31 of the Texas Election Code that outlines the process for appointing an elections administrator. What's involved there is the county will create the office. The County Election Commission convenes, and the County Election Commission is made up of certain individuals, county judge, the political party chairs, the county clerk, and then the tax assessor collector, those individuals that have those responsibilities now.
Just to catch on what you just said, it's made up of a bunch of people that are elected officials in their community, including the Republican and Democratic county party chairs. Is that correct?
Yes, sir.
So in every county that has an EA, no matter what the makeup of the county is, we've got a bipartisan group that is part of this board, this small board that elects the EA. Is that correct?
Yes, sir. The County Election Commission is the one that makes recommendations on the appointment of an elections administrator, yes.
Thank you. Let me transition for a second. One concern with this bill is the enactment date. It is September, but that runs up on the October registration deadline for the November election. Administering that election, not to mention 2024 primaries, I'm a little concerned about just the logistics of, we've talked about how big Harris County is. If this takes effect September 1, and then we turn around and have an election there in November. Have y'all thought through the logistics that this would take effect and what that transition looks like? And I guess I'm asking, is the timeline workable with an election right around the corner?
Honestly, sir, I think that's a better question for Harris County. For the folks that may be impacted by that. I can't really speak to what would happen in that transition and how they would navigate that.
I appreciate that. I guess then my next question will be for them as well, so thank you.
Members, any other questions of a resource witness? Thank you. Thank you.
I have one real
Yeah,
quick.
Representative Dayala.
And just following up, Mr. Chairman, if I will, on my colleague, Mr. Morales, who mentioned elected officials are elected by popularity contest. I hope I'm not sitting here because of a popularity contest. But I think that the folks that run for county clerk and tax assessor understand that that is part of the role of their jobs when they run for those offices, especially in Harris County. And has it been your experience that those two elected positions have more, how can I say, they're more closely tied to the voter? When they do not do their jobs, it is more recognizable and understood by the voters, and there's more accountability to the voters when those officials don't do their jobs, as opposed to an election administrator. Has that been your experience?
I think that's probably a question that's better posed to the individuals within that community. I do know that, what I can say is that there are many counties out there that feel like accountability to voters is very important. And that is why I have been told by a good handful of counties why they have not adopted an elections administrator, because they want the person or the individuals in those roles being accountable to voters. But again, that's going to be a very community-specific issue. And I think a question that should be directed to the individuals within that community.
And just very generally, without going through this list of audits and problems with Harris County since 2020, in your experience, have the complaints with respect to elections in Harris County been more since 2018 or less since 2018?
Yeah, I don't have the data in front of me to tell you. I mean, I can, we do track our complaints that we receive, official complaints that come in our complaint forms that we, look to see if they're making allegations of criminal conduct. I don't have those numbers in front of me, so I couldn't tell you if we've received more or less.
But without going into all of the details, they've been considerable since 2018. Is that a true statement? The complaints?
Yes, sir. We have had complaints about Harris County since 2018.
Thank you.
Members, any other questions? Thank you, Ms. Atkins. Now, we have a number of witnesses on this particular bill besides Ms. Atkins, okay? The issues with Harris County's elections are fairly well documented. I would ask you that you stay factual on your testimony. We can get in here and talk a bunch about subjective opinion kind of things, but let's stay factual on it. If you find yourself unable to do that, maybe we ought to think about cutting our testimony short so we can move through this and be respectful of everybody's time. The chair calls Elizabeth Barron. Elizabeth Barron. Elizabeth Barron, I show her testifying on behalf of Texas First and herself, and she's for SB 1750 and not here to testify. The chair calls Wes Bowen. Mr. Bowen, I show you're here on behalf of yourself and you're for SB 1750. Is that correct?
That is correct.
Go ahead.
Well, I'll keep it short. So I can relate. I'm not in Harris County, but I can sympathize. From 2010 to 2020, Dallas County had an election administrator that was, well, let's just say she didn't seem to respect the nature of bipartisan elections. She didn't seem to respect the need for transparent elections, and she was hired, and there was nothing that could be done about it. So I would think something needs to be done. I agree it's not the be-all, end-all solution to the problem, but I'll just leave it at that, and I support the bill.
Thank you. Members, any questions? Thank you. The chair calls Dr. Susana Carranza. She's a frequent flyer here, folks, at elections. You're here on behalf of yourself, and you're against SB 1750, is that correct?
Yes, and I'm going to avoid talking about areas that I know other folks will likely be talking about. I'm going to focus on a couple of things. First, you mentioned the size of Harris County. There are 25 states that have populations smaller than Harris County. So just for perspective. There is no state with higher population density than Harris County. And there are only two counties that are bigger than Harris. One is in Los Angeles County in California, and the other is Cook County in Illinois. So this is just for perspective. It has nothing to do with my testimony. On my test, I want to focus on a couple of things. One is this affects Harris County, clearly. But the bill is being heard today by using a change of the House rules and setting the bill like with 48 hours notice, which means that it's very hard for sufficient people from Harris County to be able to come here, make plans, and have their voice heard. So there might be some people from Harris County, but not sufficient people because it's too short of a notice. The other thing is constantly changing systems. It's just set places for failure. Like thinking that all of a sudden magically by removing the EA that barely had enough time to kind of go from a system before of county clerk to elections administrators, it's like it's finally kind of starting to get into the motion, then go back to another system. Think that will solve something. It's a little bit, to me, illogical. If anything, keep changing systems will set the county for failure. So that is not the solution. If there are problems, you need to address within the system, but every time you change, especially as was mentioned before, the short timeline, just ahead of massive elections in 2024, we know what happens when we change things too quickly, too drastically, and don't have enough time to vet. So I oppose this bill. Please don't set Harris County for failure. Thank you.
Thank you, ma'am. And members, any questions? Thank you, Doctor. Appreciate it. The chair calls Russ Long. Mr. Long, I'll show you're here on behalf of yourself and your 4 SB 1750. Is that correct?
That is correct.
Go ahead.
Okay. Second here. So the map before you is my analysis of 121 polling locations that were short of ballot paper. The map confirms a remarkably high concentration between the undersupplied polling locations and the historic home of Republican voters. This region, that crimson red area on the map, represents 208,000 Republicans. It's striking that 111 of the polls land inside that zone. Mathematically, the probability of 111 out of 121 only affecting Republican areas being a random occurrence is less than 1%. In fact, it's exactly 0.00021%. So we're talking 0.02 of a percent, 0.02 of a percent, indicating that these predominantly Republican polling locations were intentionally disenfranchised. Conversely, the math on that means that it's 99.99979% probability that this was intentional. And with that, I'll take your questions.
Representative Swan.
Thank you, Mr. Chairman, and thank you for coming, Mr. Long. I've seen the map before here and find it very, very concerning, very convincing, and wanted to bring up on April 24th, the Houston Chronicle ran an article stating that Texas lawmakers are using an imprecise map to pass this bill. Is this map imprecise?
Heat maps, by their nature, are an aggregate function, and so around the edges, it gets fuzzy, okay? But it's not imprecise. When you're dealing with engineering and data science, you talk about tolerances. You don't talk, using the term imprecise is imprecise, okay? So you set ranges and boundaries. And I can tell you, since I'm the one that generated this, these numbers are bulletproof, okay? That data that you're looking at, both the red heat map area, that's generated from over 12 years and 15 million different voters' records that have basically just been filtered, no manipulation of any type. And then and all of this data comes directly from the Harris County Election Administration, as well as the dots, the polling locations that are shown, that came from the Harris County Election Administration's report that they issued here a couple months ago. And KHOU, Channel 11, Jeremy Rogalski is the one that processed that information originally. And so the map you're looking at is accurate. It's not quote unquote imprecise, it's exactly what it's supposed to be. You could take a police sketch artist and the result that he comes up with might be a little bit fuzzy, but it definitely points to the perpetrator. So, yeah.
Follow up here. Thank you, and I'm certainly very familiar with you, that you're very well respected in Harris County for what, decade and a half or more on your data and your research. The same article states that 121 polling locations did not run out of paper. So how do you respond to that?
Okay, first off, no one that's involved with the data or any of the cases, or Senator Betancourt, is saying that 121 ran out of paper. Okay, there was 121 locations that were short of paper. They were undersupplied. These 121 roughly received half of what they would need from a normal election cycle, the historic amount. So they were undersupplied, and what that undersupplying gets to is intent. Okay, it's like a hammer. You can take a hammer and you can build something, or you can take 121 swipes at somebody's head. Okay, in this case, 26 of those swings were actual blows there. So I'm a very factual guy. I don't normally try to go to intent because you're trying to get into somebody's head. But when you have actions like this, where there's only 10 outside that Republican area, okay, 111 inside, that does go directly to intent, with the probability being so minuscule. This is, in a case like this, what you have is either extreme incompetence or malfeasance. That's all you're left with when you have this kind of probability. And looking at, the way that this hit, if it was incompetence, then you would expect that it would be all over the county, okay? But this looks to be directed, and mathematically it backs it up.
Thank you. Yes, ma'am, you have another question?
It does kind of all tie together. Thank you. So as I spent about 23 years being an election judge, and of course I'm not qualified now being an elected official, and during the years way back when we had the punch card system, I remember being amazed whether we had a Republican or a Democrat running the elections as elections, what do we call it, county clerk, the amazing number of extra punch card ballots they gave us. We would bring back far more ballots than we used. And I remember so many times saying, I don't need all these. I don't want to lug these to the polling place. I don't want to lug these back. And they go, we don't want you to run out. They literally, I would say, gave us about 3 times as much as we needed. And it didn't matter who was in charge, Republicans, Democrats. And so I find it very disturbing, all the people I've talked to and the affidavits where people, well, in these stories, the actual articles, where they could look at 4 years ago and pretty much predict, you take that, you add a little more for population increase, and then I would say double that. This ballot paper is pretty cheap. And so we had many people who asked when they picked up their supplies, like, this isn't enough, this isn't enough. Didn't matter. They wouldn't give them any more. So I find that really, really disturbing, and just wonder, like, why do you feel like this bill is important to more than just Harris County?
Well, as was pointed out, Harris County is larger than a lot of states. And so what happens in Harris County follows throughout the rest of the state. All portions of the state are going to be impacted by what happens in Harris County. But to your point about asking for paper, I was the presiding judge on this, and have been the presiding judge for several years. When I picked up my paper, I instantly recognized that was not enough. That was not what we normally got to go through an election. So I requested additional paper, and they told me that they couldn't give it to me. I would have to call in on election day. So I picked up the phone at 7 to let them know that my poll was open, and there was no answer, okay? We went ahead and had people start to come in that had different issues on casting their ballot, and I attempted to call in. Okay, no answer. I was not able to get a single soul from the election administration office there until after 1 o'clock. At that point, I asked for more paper because we were already getting short. Plus, we were having other issues with machines. Had 3 machines that were breaking down. And we did have a tech come by to repair one of the machines. The others were still down.
Mr. Long, I appreciate that.
Yeah.
Like I said earlier, a lot of these issues are well documented. I understand. I don't want this to turn into just a gripe session about it, but I appreciate your testimony of your factual basis. If there's no other questions of this witness, members, we're going to go to another witness. Thank you, Mr. Long, for providing us with this map. The chair calls Alan Vera.
Morales, this is for you.
You're Alan Vera. You're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for SB 1750. Is that correct, sir?
All correct.
Yes, sir. Go right ahead.
You don't need to hear any more testimony about how bad the elections are in Harris County. What you need to know now is that the leadership in Harris County will not fix the problem. They had a chance to do so and refused to do it. The handouts I've given you have 3 documents. 1, my testimony to the Harris County Elections Commission on April 19th, 2022, as the commission was beginning the search for a new elections administrator to replace the one that was forced to resign for totally botching the March 1st primary election. 2nd document with red ink on it. Our revisions, printed in red, recommended to the County Elections Commission for changes in the job description versus what they were about to send out. 3, a set of questions we recommended to ask every finalist for the job. We told them that the definition of insanity is doing the same thing over and over again and expecting different results. We handed them on a silver platter the roadmap to avoid a repetition of the mistakes they made hiring the first EA. The county judge actually at that meeting made a motion to incorporate our red line job description changes into the job description given to the search firm. It passed 5-0, and the search firm completely ignored it, and the commission let them get away with that. 2.55 million registered voters in Harris County know the county leadership is not going to do anything to fix this problem. That's why we need you to step in. When a school district fails year after year, you authorize TEA to step in. We need you to step in now and report SB 1750 favorably to the full House. Thank you.
Thank you. Representative Swanson.
I only have one kind of long question. Since, Mr. Vera, you represent the Harris County Republican Party, and I'm sure you realize if this bill passes, then it'll be 2 Democrats, the ones running the elections. So the Democrat elected as county clerk and the Democrat who's currently elected as the county tax assessor, who's the would become back again the voter registrar. So my question is, does that represent a problem for you and the Republican Party?
Not at all, and this addresses something Mr. Busey asked earlier. Ms. Hudspeth, the current county clerk, has 7 years' experience running elections in Harris County before the county flipped to an EA. I have no concerns about her ability to step in and properly run an election because of the years of experience she's had prior to that.
That's great. Thank you.
All right.
Members, any other questions? All right. Thank you, Mr. Vera. Appreciate that.
He's the county clerk.
The chair calls Christopher Russo.
And she's got a great reputation. Yeah, Janice.
Mr. Russo, I see you're here on behalf of yourself and that you're for SB 1750. Is that correct?
That's correct, Mr. Chairman.
Go right ahead.
Mr. Chairman, Vice Chairman Busey, my name is Chris Russo. I'm representing myself, and I am testifying in favor of SB 1750. On Election Day last November, I was the presiding judge at the City of El Lago City Hall polling place in Harris County. What I experienced should never happen in any election in our great state. After some initial equipment failures, we started processing voters at a pretty steady clip, and I realized around 2:30 p.m. that at the pace that we were going, we'd eventually run out of ballot paper. I called the Elections Administration supply line, and after a drop call and long hold, I was eventually told that someone would be on their way with additional supplies. These never materialized. I called several more times throughout the afternoon and was told at least one more time that ballots were on their way. They never came, however, and we ran out of ballot paper in the middle of the after-work rush around 6 p.m. We had about 40 people in line at the time, most of whom left to find another polling place. I told the people in line that if they stayed in line, they would be able to vote, but I did not know when we would receive more paper. I kept calling the Elections Administration and was told my case had been elevated and that ballot paper was on its way. I finally received ballot paper at 9:05 p.m. By that time, only 4 people remained in line. I would estimate that approximately 100 people who came to the polling place to vote left because of a lack of supplies. Even worse, 2 nearby polling places also ran out of ballots, making it even more difficult for people in my area to vote. Many people that came while I had no ballots were on their second or third polling place they had attempted to vote at. Whether by malfeasance or gross incompetence, this election administration disenfranchised many voters across the county at polling places like mine. This can never be allowed to happen again in Texas. Thank you for your time, and I urge swift passage for SB 1750.
Thank you, Mr. Russo. It was egregious. No question. Members, any questions? Thank you. The chair calls Thomas Burrows. Mr. Burrows, I show you're here on behalf of yourself and your 4 SB 1750. Is that correct?
Yes, sir, that's correct.
Go right ahead.
You know, this is not just Harris County that this is happening in. Dallas County does not, it's basically a patronage thing. You know, they let the bridge and road crew people have vacation so they can come in and work. 2020, I worked in Highland Hills. I had my life threatened. I informed the person that threatened me that, you know, one of my relatives is a Texas Ranger, you know, one riot, one ranger concept. So I'm not a good person to kill.
Mr. Burrows, we need you to stick to the bill.
You know, and so I was personally told, I was being cussed out, yelled at, screamed, had stuff thrown at my car. And on the last day of voting, they had so many ballots in the DS-200 that it wouldn't work anymore. So the election judge told me, you have to leave or I'm having you arrested. Well, I didn't really want to take the ride to Dallas County Slammer, Lou Sterrett, you know? I mean, I got better things to do than that. And we had an incompetent, I'll be honest with you, an incompetent county chair at the time, and he was having a birthday party with his wife.
Mr. Burrows, I need you to stay on the bill.
So the point is, this goes on a lot of places. It's not just Houston, not just Harris County. It's corrupt in Dallas, too.
Okay, thank you. Members, any questions? Thank you. The chair calls Ken Moore. Mr. Moore, I show you're testifying on behalf of yourself and your 4 SB 1750. Is that correct?
That is correct.
Go right
ahead. My name is Ken Moore, and I used to be election judge in Harris County back before 2018 when things worked pretty well. Over the years, I've watched things decay. I've seen the election process fall apart. And one of the perspectives I want to give you is on April 5th, I was in the Commissioner's Court, and I was on this occasion, Kim Ogg, the Harris County District Attorney, came into the court and gave the commissioners a good dressing down because she had just lost money that they'd taken money out of her account that she had planned to use to hire more prosecuting attorneys. Now, 2 observations I'll make to that, and I will apply this to the bill. Number one, she could get away with it because she didn't work for the commissioners. She worked for the voters. And the commissioners could not fire her. She could say whatever she wanted to. And number two, she was motivated because she didn't want to go face a bunch of angry voters asking her why rapists, murderers, and thieves are not being prosecuted. And so she had a reason to go in there and argue to get her money back. And my understanding is she got just what she wanted. And this is the difference between someone who is elected and is amenable to the voters and someone who is appointed and serves at the pleasure of those who appointed them.
Yes, sir. Members, any questions? Thank you, Mr. Moore. Appreciate it. The chair calls Emily E.B. French. Ms. French, you're here on behalf of the Texas Civil Rights Project and against SB 1750. Yes, ma'am. Is that correct?
Despite the tone of surprise, that is correct.
Yes. Go ahead.
Yes, sir. I am here to testify in opposition to SB 1750. This bill would effectively rob the largest county in Texas of the ability to determine who runs their own elections and force other large counties to worry about coming under this bill's purview as Texas grows. Currently, every county in Texas chooses whether their elections are run by an appointed elections administrator or the combination of a county clerk and tax assessor collector. There are notable benefits to the elections administrator system, including the fact that they are a nonpartisan appointee who can spend all their time working to ensure a free and fair election without worrying about their own upcoming campaign. Moreover, just because problems arose in an election administered by an EA does not mean that the solution is to revert back to the old county clerk system. For instance, as TCRP documented in a report on the 2018 election, which was administered under a former Harris County clerk, at least 18 polling places in Harris County either opened late or were so plagued by machine errors that they might as well have opened late on Election Day. This ultimately triggered Election Day litigation that kept the polls open for an additional hour in 2018. The clerk at the time, the clerk himself described these massive breakdowns as typical. Harris County has seen successes and problems under both county clerks and election administrators. Like every other Texas county, they deserve the right to exercise their own choice about how to run their elections. We ask you not to report this bill favorably.
Members, any questions of Ms. French? I think the vice chair does.
Thank you, Mr. Chairman. Ms. French, I know it's late, but we've been given this flyer here multiple times. It references a KHOU article that is using the stats based on initial papers sent out and how many votes cast, not taking into account if more shipments of paper were delivered. I'm not excusing anybody ever getting it turned away. I think we could look around the entire state and find hiccups and malfunctions, but that does not justify why we would take over a local county. I just think, though, as we have this conversation, let's reference the Houston Chronicle article that did a deep dive into this. Have you read that article where it talks about actual numbers and how many areas where the original 121 based on a poor data point and where reality is?
I have, and what I'm about to say I know sounds like I'm saying it just because Chair Kane is here, but I have spent all day tweeting about this, so I'm sorry in advance.
I haven't seen these.
No, I'm on Twitter all the time anyway. But I only 26 of the locations, I don't even believe all 26 locations are included on that 121 map, but only 26 locations actually made it into the lawsuit. For paper shortages, I believe there are 3 other locations that are in the lawsuit as well for machine malfunctions. But of those 121, only 26 even have enough proof to be, heard.
This lawsuit is brought by the Harris County Republican Party, correct?
I believe
They didn't bring a lawsuit against 121 sites. They brought it against 26 sites.
Right. And I think the map is a little misleading. I understand that it's a heat map and heat is red on heat maps, but I think that there are some places that were more democratic traditionally that also experienced some of the shortages, which I think it's a little misleading to just look at the map and think, oh, red Republican, this was a conspiracy.
I think to everyone's point here, we want to not have anybody ever get turned away. I think everybody agrees with that. We also have to realize we live in reality. There's going to be hiccups. There's going to be malfunctions. There's going to be little things. And let's talk about facts. And I think when we talk about 121 versus maybe 20, and many of those for 15 minutes or less, we need to live in reality when we have this conversation. I appreciate it.
Thank you. Yes, Representative Manuel.
Hello. So I have a quick question, hopefully. There's been a lot of maps going around, a lot of conversations. Have you seen any of the maps from districts like Sunnyside, 3rd Ward, 5th Ward, when they were complaining that machines were not even on, that they weren't functioning, that there would be water shortages where machines would get short-circuited? This was under different administrations. This was way past the 12 years. Have you seen those maps? Has anyone brought those maps forward anytime soon? The complaints to the legislator during that time?
Right. I have heard about a lot of those problems, especially happening in the areas you cite, and as well as happening all over Texas. We help run the 866 Our Vote hotline, myself and some of my colleagues in my testimony peanut gallery as well. But we hear from counties all over Texas, big, small, clerks, EAs, about problems like that constantly. It's not just Harris County. It's not just counties with election administrators.
So it's just currently right now, Harris County just is the big target.
We are hearing a lot about Harris County right now, yes.
But there are problems that are happening throughout the state in different areas.
I would say, I don't say this to put any county on blast. I think elections are incredibly difficult. Sorry, technical term on blast. I don't say this to bring any county under an additional target.
I mean, my county, we're suing, so I get it. That's why I'm asking.
I think it's just really, really hard to run an election. And when a county does not receive institutional support from its state, when a county comes under fire constantly, it is harder to build an infrastructure that will run better and better elections as opposed to an infrastructure that faces a lot more problems.
So it could be a multitude from the state to state laws to local officials who are having to fund these elections, who are having to make sure that the right person is there. It could, and I'm not, again, not making an excuse for any county, but I'm saying, could it be more than one avenue that's causing a systematic breakdown?
Agree. Yes, I think it definitely could be more than one. It definitely is more than one avenue. And I, like you, don't want to excuse any problems. I work for the Texas Civil Rights Project. Works for the voters first and foremost. I'm not here to defend any particular county. Just want to make sure that counties get the support they need to build something that serves the voters.
Perfect. Thank you so much.
Thank you.
Representative Ayala.
A couple questions. First, we talked about a subset of those polling places on the heat map. And there was 21 specific polling places that had substantial paper shortages, of which 19 of those were predominantly red on the heat map, Republican places. Are you familiar with that analysis as to those, the larger polling places where the biggest discrepancies occurred? Are you familiar with that?
If I had the Houston Chronicle map in front of me, I would be able to say with more certainty. What I recall from looking at it earlier today is that there are shades of blue and shades of red, and especially in a countywide polling county, you'll get all types of voters at all types of polling places.
Are you following, with respect to Harris County, the amount of money that has been spent on elections over the past 8 years or so?
I'm not following it specifically. I assume it's comparable to other large counties across the state.
Do you understand the increase in spending on elections in Harris County has been considerable in the last 6 years?
I would assume it has in comparison with other similarly large counties across the nation.
And then last thing, you mentioned that the election administrator was maybe I'm not using the right word, but I think you said nonpartisan appointee. Did I say that right?
Mm-hmm.
Would you consider the Secretary of State to be that same type of appointee, a nonpartisan appointee?
That's a good question. I think that the elections administrator is appointed by a body of folks, whereas the Secretary of State is only appointed by one. So it's easier to have a nonpartisan appointee. Well, maybe more like a bipartisan appointee for election administrator.
And you understand that in Harris County, there may be one person on that committee that might be of a different party than the Democrat Party. And when we do a Secretary of State appointee, there's a whole Senate that has to confirm that.
That's true, but that is a different process.
I understand. I just didn't know if in your mind you considered one nonpartisan and one the other, and one not partisan.
It's a fair question, and I think that the processes are different enough.
Thank you.
Members, any other questions? Ms. French? Thank you. Good to see you. The chair calls Cindy Siegel. Good evening, Ms. Siegel. Good to see you. I understand you're with the Harris County Republican Party, and you're testifying on behalf of the Harris County Republican Party and yourself, and you're for SB 1750.
Correct.
Is that correct? Go ahead.
Good evening. Ensuring free and fair access to the ballot is fundamental to our election process. Voter suppression is when you go to vote and your poll isn't open because the equipment doesn't work. Voter suppression is when your ballot doesn't reflect all the races you can vote in. Voter suppression is when you get the wrong size ballot paper and your vote for half the candidates isn't recorded. Voter suppression is when your ballot's not secured and it's one of many left in someone's truck and the EA's office tells the judge, just bring it in the morning. And of course, voter suppression is when you go to vote and there's not enough ballot paper. It wasn't just ballot paper last year. There was a series of events that went on of how they messed up the elections from the primary on. We're promised as Americans our right to vote, and this right can only be preserved when elections are secure and run according to the law. As the chair of the Harris County Republican Party, I actually sit on the 5-member Elections Commission, who has a right to hire and fire the EA. However, this is the same commission that just a few weeks ago, in a vote of 4-1, voted to not discuss the November election and what went wrong and why. This commission reports to the Harris County Commissioners Court, the same entity that just sued the Attorney General using taxpayer dollars to avoid releasing information regarding that November 8th election. So why should you all care about elections in Harris County? Only 3 of you actually can vote in Harris County. As the largest county in the state with over 2.5 million registered voters, how elections are run in our county can potentially impact statewide races. It's time to give back to the Harris County voters their voice and their right to vote on how elections are run in our county versus a 5-member election commission. It's time to put the elections back in the hands of the duly elected county clerk and tax assessor. So I respectfully ask your support for this bill. Any questions?
Thank you, ma'am, for being here. Members, any questions? Representative Dayola.
Before today, this committee has heard a lot about Harris County and a lot about the issues in Harris County. And I don't want to go through those with you. But I think you have a summary in writing from some of the audits from 2020 that perhaps you could share with the committee at some point.
Yes, we can provide that.
Thank you.
Any other questions, members? Thank you, ma'am, for being here.
Thank you.
Thank you
Appreciate
for
it.
coming.
The chair calls Katia Arisman. You're here on behalf of Common Cause Texas and yourself, and you're against SB 1750, is that correct?
Still true, yeah.
You go right ahead.
Yeah, thank you so much. I'll try not to repeat. I think Emily did a really good job of opposing or laying out some of the opposition to this bill. I think mechanically this bill is a really dangerous precedent for the legislative body to set, abolishing the position of the election administrator in the 3rd biggest county in the country and the biggest county in Texas, as they've begun to gather more information on administering elections post SB 1 under countywide polling, makes Senate Bill 1750 a problem in search of a solution. I think if we're talking about, the way that politics has been injected into our elections administration and the accountability notion that multiple witnesses have come up here and talked about, under the kind of model outlined by 1750, there would be 3.5 years until there's accountability under a form of an elected official taking over these election administration duties, whereas an election administrator is more promised to be a professionalized election, and there is accountability through the way that the officials on the commission can be elected within the time to oversee the responsibilities better. The 2020 2022 elections were a completely new baseline for Harris County, and we're not going to get up here and defend the administration of the elections in Harris County, but the fact that this bill is not going to be setting guardrails to ensure better elections are possible going forward. It doesn't actually establish any new funding or new resources for the ability for Harris County to actually administer an election. And what it does is it asserts a punitive solution as opposed to a productive solution in administering elections going forward. And so, for a lot of reasons, we oppose this bill. We can talk more about the map and the data that's been presented so far, but we, urge the committee to oppose 1750.
Thank you, Ms. Harrisman. Members, Representative Day.
One question. First of all, Chairman, thank you. Ms. Harrisman, you are one of the fastest talkers.
So sorry.
And in a very understandable way. Some fast talkers you can't understand. You're wonderful at it. So that's number one. Number two is when you say there's no funding for this.
Sure.
Do you have any reason to believe that the problems in Harris County is due to a lack of funding? Has that been shared with you?
I think that this is a good question. I'm glad this is something that we're able to talk about in multiple witnesses. I don't think it's necessarily because of a lack of funding, but a lack of the equitable funding for the resources that we're seeing in multiple elections. As I think Emily mentioned, 2018 we saw problems in administering elections. 2012 we saw problems in administering elections in Harris County. 2008 we saw problems in administering elections in Harris County. Those were all under the county clerk model. What we saw uniquely in 2022, which this bill seems to only be a backlash to as opposed to a productive solution for, is the fact that this was now under paper machines. This was now under countywide voting. This was now under, a new election administrator that had a few months to adapt to that role. And, I don't think that, spending in regards to the voter education or the new machine adaptions is something that we necessarily know where the line item allotment was for, but it is something that, when we've seen these problems persist under an EA, under a county clerk model, under a TAC model, it seems like as the county continues to grow massively in the context of the nation, maybe continuing to allocate our resources when Texas is noted by the nation to be the most chronically underfunded system compared to most models seems to be a solution that we should be looking towards. Let me
Just cut it to the quick.
Sure.
It's not that we didn't have enough money for paper last cycle. That wasn't the issue, was it?
I don't know what the line item for the paper allotment was. We did see in 2018 that ULIS and Dallas also had paper, jammings, and so I think that we'll see.
No, and that's, my question is very specific. I didn't want to get into a lot. Is there something specific about funding in Harris County that you have been told specifically, not in general, but specifically, that led to the problems that Harris County had in the last 2 or 3 cycles?
I'm not privy to that specific answer.
That was my question. Thank you.
Thank you. Members, any other questions? If not, thank you, Ms. Harris.
Thank you.
Chair goes Marcia Strickler. Ms. Strickler, do you have anything to this discussion you want to add?
Well, I have a little bit of a different perspective here. I did.
If you're going to, I need to confirm that you
Williamson.
that you're here on behalf of yourself and you're for SB 1750. Is that correct?
I am for it, and I testified in the Senate for it, but I did ask Senator Betancourt to think about changing the 1 million to $500,000 so that it would encompass the top 12 counties, the top 12 problematic. Briscoe. The top.
Watch him.
He's behind me. I gotta watch him. So Williamson County is number 11 in terms of population. And we have an election administrator, and we've had an election administrator for some time. Not the same one always, they do move in and out. I think the one we have now, Busey, what is it, 12 years, something like that? Has he been with us that long? I think. Rep Busey, I think it's 12 years. I have an interesting thing I want to read to you here. 1 in 5 election administrators across the country said that they are very or somewhat unlikely to remain in their positions through 2024, according to the March 2022 survey from the Brennan Center for Justice. So These election administrators are hired by 5 elected officials, and they may be Republicans, they may be Democrats. In our case, there's 1 Democrat. All the rest are Republicans. But we still in our county, and I'm a Republican, we still in our county have a problem talking to those 5 officials about problems that we have with our election administrator. So I do believe that all citizens, we the people, would be served better to have an elected official running our elections, because we then can control whether or not we vote that elected official in or not. So now that this is a 3.5 million population, we're not going to be there anytime close. I thought 1 million, well, we're the fastest growing county right now, so we will get to that 1 million pretty quick. So I would like it to go back to 1 million.
Thank you, ma'am.
Thank you.
Members, any questions? Thank you, Ms. Strickler. Chair calls Susan Hayes. Good evening, Ms. Hayes. I show you're here testifying on behalf of yourself and you're against SB 1750. Is that correct?
That is correct, Mr. Chairman. Thank you for having me. My name is Susan Hayes. I'm an attorney. I'm board certified in civil appellate law as well as legislative and campaign law. I've been practicing election law for over 20 years in the state. In the 2020 election cycle, I represented Harris County in the dozens of lawsuits that were filed against it every time the then county clerk tried to make it easier and safer to vote during the pandemic. I am currently representing Republican clients in an election contest in Loving County, where the county clerk runs the elections. And I came up here at this late hour, both because I believe in democracy, but also to try to warn y'all of what happens if you force a county to keep its elections administration out of the hands of a professional, hired, focused elections administrator and into the hands of a partisan elected official. And what I have seen on the other side of this, in the current litigation I'm involved, is a county clerk who printed their own ballots, did not keep tracking audits of them because their deputy was in a second election after a tie. And there's not much one can do to fix that during the election. You can't fix it between that and the next election of that county clerk. But an EA who screws up can get fired right after the election. I know this whole state has been so submerged in partisan bickering, but this is the structure of our democracy. It's the structure of how we function as a society. Think twice when you react this harshly to an election that did not go well. And Representative, you've had a lot of questions about funding. Funding absolutely does matter. There was a lot of private funds that came into our elections administration during the 2020 cycle, and that helped tremendously to help things go more smoothly. But this body chose to ban that. And that, again, was perhaps not a wise thing for democracy, so long as there's transparency on that sort of thing. So unless anyone has any questions, I've had my say.
Members, Representative Manuel.
Hello. I have a question, and I'm probably going to play devil's advocate for just a second. We keep talking about funding. We keep talking about we're targeting one county because the bill specifically is addressed at one county. Mm-hmm. Do you think the solution would be a centralized voting system or a centralized funding and laws for all 254 counties?
I think counties do need help, and they need to make sure they have adequate funding. And we also need to make sure there's professionalism in the management of election administration. Some counties may have a superior county clerk who can run an election very well. The county clerk who served here for many years in Travis County, Dana de Beauvoir, was fantastic. But that can turn on an election. You may have a small rural county where somebody simply needs help. They've got a lot of other responsibilities, and that's one reason why elections administrators are so important. I myself grew up in Brown County. It's a medium-sized county, 40,000 people. Even they have an elections administrator. It's not that big of a county. It works wonderfully because there's someone focused on that job and doing the planning. And this has come up in the testimony earlier. Running elections is not an easy thing. In Harris County, there are 6,000 election workers for a general election. That's a lot of people to manage. There ain't no way that's going to go smoothly. There's going to be problems. It's how you respond to them. And if you don't have the adequate funding to respond to them, to train people to respond to them, to have, and one innovative thing Harris County did in 2020 was send out sort of a mid-management strike force, and that's the wrong phrase for it, to help support election judges who had issues, somebody they could text or call and come right away and help them. But they were awash in cash because of the extra funding during the pandemic in that cycle. So that's absolutely would be important.
How, in your opinion, looking at Harris County, looking at the county that you're representing because of an issue that has happened, how has consistent laws changing either hurt or made voting, the process for voting in any county, either worse or better?
Right, and to clarify one point, I'm not representing Loving County, I'm representing three candidates who were Republican nominees for office. And I will say, and please do not take offense to this, I have joked for many years that the problem with the election code in Texas is every member of the legislature thinks they're an expert. So every session, the laws change, and unless there's a good reason for change, it's just more for all the staff to learn and figure out and change the forms and change the training, and crotchety old election workers may not like that. So changing laws just to change them isn't always the wisest thing. Adequate training there's never enough of. And also, it's additional piece of my background, I was the Democratic Party chair in Dallas County 20 years ago. It is no small thing to find enough election workers to work a primary in a county that big, or the general election, and they are the full spectrum of humanity. Some of them are lovely, some of them are not. So that extra support to, particularly in the bigger counties or even the fast-growing suburban counties, to have well-trained professional staff would go a long way to avoiding the kinds of inevitable problems in running an election.
So this really should be my last question. Because I'm going to go off of what you were saying. So there's 6,000 employees in Harris County just for the elections. And every single time we have a law or new laws that are put into effect, we then in effect have to get people on a dime or in an instant to learn these laws, understand these laws, implement these laws across the board, not just from election administrators, not just from county clerks, but from every single person, every single time those happen. And we have to expect they just have to get it.
Absolutely. And across the board, not just election law. And one of the unanticipated matters for me I had to handle in 2020 was a sexual harassment issue with election workers, hitting on high school clerks that were working the election. And because during early vote, the election judge is then the county clerk or would be the elections administrator, so there's a clear boss to hire and fire, but on election day, it's that precinct's election judge. So the guy who was doing the harassing got to come back and work on election day. I mean, think about putting up a corporation or a business and hiring 6,000 people and expect them to execute it perfectly and not have any problems. And are you putting the right power in the right hands to make it an efficient operation?
Okay, thank you so much.
You're welcome.
Did you say earlier that you had represented Harris County?
During the 2020 election cycle.
In the 2020 election cycle? Okay. And did you represent anyone in connection with Harris County elections in the 2022?
I did not during 2022.
Did you?
So what I know, I read in the papers.
That's it?
Yeah, including the Houston Chronicle's very lovely series this last week debunking the heat map.
Okay. So would you, from what you've gleaned, from your representation in 2020 and then what you have learned about the 2022, would you say that the elections were worse, handled worse in 2022 or better?
I think they had more problems. They also had a lot less money to run them. Because there was, like I said, a lot of private money came in 2020, not just for Harris County, but for many counties around the state. I particularly recall Arnold Schwarzenegger giving poor Cameron County $250,000 to help them run their election, something that's now against the law.
Are you familiar at all with whether or not Harris County purposefully reduced the funding to its elections administrative office for the 2022 election cycle?
I do not know whether the amount of money the county put in reduced. I know the total budget reduced because of that lack of private money.
Okay.
So I've not studied the most recent budgets on it.
If it were revealed to you that the county had in fact reduced the amount of money that it put into it, would that sound like that made good sense?
Well, it wouldn't entirely surprise me because we weren't in a pandemic and it was a different election to run. I mean, something incredibly innovative Harris County did in 2020 was they moved their whole offices to the Toyota Center so their staff could socially distance. That wasn't cheap. They did the drive-through voting so voters could socially distance. That's now been banned. All that innovation costs money. All that extra rental space costs money. So it would not surprise me at all that the total amount Harris County put in came down because we weren't in an active pandemic at the time.
Would you agree that there are counties that are larger than Harris County that handled the 2022 election cycle in a much better way?
I'm sure that's the case. And, you know, I have been somewhat bemused by all the pearl clutching over Harris County when I got to tell you something, I'm older than I look. And I have remembered many an election where polls shut down back when we had all paper ballots. I'm that old. Whether in Dallas County or you'd hear rumors of Harris County during the election, it always seemed to be a shortage and not enough. And there are pros to electronic voting, there are cons. I'm glad we have paper backups in the systems now. I do believe Harris County was doing their first election with a new election machine, and that is always going to be rough road. No matter what the county, the first cycle's always got some problems. You got to work the kinks out. But I do not for a minute believe there was any purposeful cutting of the budget to make it more difficult to vote in a county with that political makeup and with the political leanings of the county. That's illogical.
Members, any other questions? Real quick.
I just wanted to correct some misinformation that's been mentioned, that in 2018, the budget was $12 million when we had Stan Starn running it as our county clerk. Last year, the budget was over $30 million to run the election. So it's not a funding problem.
Thank you. Members, any other questions? Yes.
Yes, sir.
The 2022 election was in Harris County. Would you consider that to be a successful election?
I don't know enough. Right. I do not know enough details about it. I feel like it wasn't such a successful election because the turnout was not what I would have hoped. And I say that because I was a candidate for agriculture commissioner. Right. Like I said, there are always issues. How do you deal with them? How quickly do you mitigate the harm? And does the department have adequate resources to do that? And if somebody is screwing up in management, fire them. You can't do that when a county clerk's running an election.
Only the voters can.
A couple election cycles later. Yeah.
Members, any other questions? Thank you, Ms. Hayes, for being here.
All right. Thank you very much, Mr. Chairman.
Absolutely. Chair calls Robert Kinney. Mr. Kinney, I show you're here on behalf of yourself and your 4 SB 1750. Is that all correct?
Yes, sir, that is.
You go right ahead.
I just want to say for the last 40 years, I've worked as a clerk, election judge, and alternate judge in Harris County. So if anybody has a question about this, and I'm not going to repeat what all these other people have been saying.
When did you appoint?
Pardon?
You were employed there?
I'm sorry?
When were you employed there?
Oh, gosh. The last time was November the 8th of 2022, and then you go back 40 years before then. Carl Smith was the tax assessor collector when I first worked the elections. He was followed by Paul Betancourt.
Members, any questions? Thank you.
Thank you, sir.
Thank you, Mr. Kennedy. The chair calls Dr. Laura Presley. Dr. Presley, you're here on behalf of True Texas Elections and you're for SB 1750.
Yes, sir.
Go ahead.
Thank you. I'd like to take what Mr. Vera said and maybe go a little further. The real reason that you're looking at this bill is because the system failed for how to correct the problems that we're seeing in Harris County. The Election Commission has a very high ceiling for replacing the election administrator and to make a decision to correct that issue. It's an 80% ceiling. 4 out of the 5 people have to vote and agree to remove the election administrator, or the county commissioner's court has to vote in a majority to remove the position. We are here because that corrective action is not possible, and something's got to be done. What I want to present to you is that these issues and going on in Harris County are going on in other counties. Bexar County, Dallas, Bell County, medium-sized county, Gillespie County, where the elections administrators are committing criminal, what I would consider, I believe, to be criminal acts. And the Election Commission doesn't have the political will to do something. We're in the same position that Harris County's in. Harris County is just a leading indicator of this election administrator problem, where you can't get rid of them unless they're under, this position is under a county clerk, where the voters at over 50% can remove them. So I would highly, highly recommend to this body that you guys go back and just make this all counties, because this is a root cause problem that you can't get rid of them, and this is no different in any other county in the state. Okay? Any questions?
Thank you, Ms. Presley.
Thank you.
Appreciate it. The chair calls Andrew Hendrickson. Good evening, Mr. Hendrickson. I show you're here on behalf of the ACLU of Texas and against SB 1750. Is that right?
That's correct.
Go right ahead.
I'm not going to repeat a lot of what has already been said. I just want to point to a couple of things. We mentioned earlier that there were 29 locations that were involved in the 22 election contests that have been filed by Republican candidates. One thing I want to highlight from the Houston Chronicle reporting is that 55% of those precincts were won by former President Donald Trump, and 55% and 45% were won by current President Biden. That's not a huge split that shows some sort of intent to have a nefarious partisan scheme when you have those located in, districts that are roughly split Democrat-Republican. And I think the other thing I just want to add to this conversation is I think a lot of the reasons for having an EA is not only just to prevent that partisanship, but also any appearance of partisan impropriety, right? You might feel as though the EA just has a little more distance from the election process because they're not on the ballot. They're never running an election that they're also a candidate in. I think one thing we're seeing, in these hearings, we've now had, I've been in a lot of hours of hearings, and I know you all have too, and we've talked about Harris County quite a bit. One thing we haven't heard yet in any of them is a voter who was prevented from voting. We have heard from election judges who have partisan affiliations. We have heard from county party officials who have party affiliations. We have yet to hear testimony from a voter who was unable to cast a ballot because of a paper shortage, and in either chamber on any of these bills. That's not to say that we're okay with delays or any issues that voters face. It should be easy. It should be convenient for everyone to vote. I think what we're seeing, though, is partisanship bleed into the process of election administration, which should be a purely ministerial function, and the EA's office is one way to create that distance to make sure that this ministerial function is run efficiently and in a nonpartisan fashion. Thank you.
Representative Morales?
You may have said this, I was checking something online. Would you prefer the EA method or what this bill does, the county clerk along with the tax assessor collector?
I think that, as the Secretary of State mentioned earlier, Representative mentioned earlier, that communities are best positioned to decide for themselves which model works for them. But I think one thing they should definitely be free to do is to choose the EA model, where you do have more of a professional and you are moving towards a nonpartisan system. I'd also just note quickly that, it's inconsistent to suggest that the reason this bill is necessary in Harris County is because they have not addressed problems, yet the EA was also only there for 3 months before this election started. The current EA has not had another election since the 2020 general election, which was the first election that EA was in charge of administering, to actually address or correct any of these problems. That's not a persistent pattern under the current EA. And so I think, it's an overreaction in this case to target one county, to abolish one office under those circumstances.
So, okay. How long has the current EA been there in Harris County?
I believe it was 3 months before the...
Right now, since they were appointed.
Since they were appointed, so if my math is correct on that, it's a little under a year, if I'm right about that. Anyway, it's late. I'm trying to think back. So November would have been, under a year.
So they were appointed last year in 2022?
Yes, so 3 months prior to the November election. So that would have been, if I am counting backwards, October. I think October, September. Or no, sorry, August. Anyway, it's been a long day.
The current EA, just to make it clear and on the record, the current EA was appointed sometime in August?
Summer of 2022.
Of 2022, and was given only 3 months to prepare for an election in November of 2022.
That's correct.
That is the same EA that is currently in place.
Correct.
And there's been, from what you can tell, there's been no movement from, I'm assuming, is it Commissioner's Court? I forget.
The County Elections Commission would be the ones could appoint that person or fire that person on a 4/5 vote.
And there's no agenda item or anything to have him remove him?
Not at this time. One thing also highlighted in the Chronicle reporting is that there have been plans proposed by the current EA in Harris County to address some of these problems, better tracking systems. There are plans in the works to make sure things run smoothly in the future. I think it's appropriate in this case to let those plans play out before we identify a pattern that may not be supported by the others.
And in those plans, has he been specific to provide a specific budget as far as what he or she would need in order to make sure that they run an election smoothly?
I don't know about the budget aspect of it, but so the 4 proposals that I know have been mentioned as things that they would want to be done, that Clifford Tatum has specifically identified, is the county would have one hotline operator for every 3 locations in the upcoming May election, which is underway now. A system that tracks calls and requests from judges so that there is a timestamp for when the requests come in, what the requests are, a log to note when the issues are resolved, and monitors for technicians in the field. Those are 4 solutions. They are concrete and that they are trying to implement now in the current May election that's going on. So, I think this is an overreaction in some ways to a single election. I'm not saying that it's okay. We sued Harris County to keep the polls open an hour later because we were not okay with people not being able to vote in this election. That is never our position, that it should be difficult for people to vote, that people should face delays, should be turned away at the polls. I think what we are seeing here is really focusing in on one county that has problems that are not inconsistent with what many on both for and against this bill have testified happens all over the state, and that, the solution here is not changing who is in charge of administering elections. One other thing noted by the Chronicle article was that the Harris County elections have been administered by 5 different people in the last 5 years. And so constantly changing leadership in this way is not a good system for having a cohesive way to address the problem.
Thank you.
Thank you, Mr. Henderson. Members, any other questions? Not, thank you. The chair calls Charles Cruz. Mr. Cruz, you're here on behalf of yourself and you're against SB 1750, is that right?
That is correct.
Go ahead.
Howdy, Chair Smith, Vice Chair Busey, members of the Elections Commission. My name is Chuck Cruz, and I'm a Harris County Democratic Precinct 0103 Chair on the eastern edge of Harris County. I'm here to speak on my own behalf, not the party. I'm here to share my lived experience, not as a representative of any organization. I served as an early vote presiding judge in 2020 and 2021, in which I accumulated months of experience working 12 and 14-hour days as an election judge, and witnessed firsthand various problems in the Harris County Elections Administration, both under Clerk Troutman, temporary Clerk Hollins, and then Election Administrator Longoria. The vast majority of problems encountered were due to inadequate logistics and training. As a retired chemical engineer with over a decade of experience in plant maintenance and risk management, I've been severely disappointed by the failures within the Harris County Election Administrations, precisely because those problems were largely due to failures of logistics and training. In the petrochemical industry, processing facilities operate safely and profitably due to successful logistics and training. While initially hesitant at the creation of the Election Administration Office in late 2020, I am today convinced that the single focus Election Administration Office is the superior method of election administration in metropolitan counties. The county clerk core functions include property records and personal records, which are massive tasks in metropolitan counties. Similarly, the Texas tax assessor collector core functions are assessing and collection of taxes. Neither county clerk nor tax assessor collector core functions translates well to election administration. The Commissioner's Court of every major metropolitan county in Texas, excluding Travis, have seen the benefit of consolidating voter registration and conduct of elections within an election administrator role, an option first made available in Texas well over 30 years ago. Today, 2/3 of Texans vote in elections conducted by an election administrator, each of which operates under the authority of the Texas Secretary of State. Now, SB 1750 seeks to revoke the power of the Harris County Commissioner's Court to choose the method of Harris County elections and only Harris County. State Senator Betancourt plainly stated his intent to punish Harris County. He wants to propagate a new big lie. The multi-purpose offices of county clerk and tax assessor collector will somehow provide smoother elections.
Thank you. Members, any questions? Thank you, Mr. Cruz. The chair calls Joanne Richards. Joanne Richards. I show Joanne Richards testifying on behalf of herself. Oh, that thing's rowdy. My goodness. Show Joanne Richards testifying on behalf of herself and against SB 1750 and not here to testify. Is there anyone else who wishes to testify on, for, or against Senate Bill 1750? If not, the chair recognizes Chairman Kane to close.
You did well. You did well. All right, members, let's think about this for a moment. You've got chair of the Republican Party of Harris County. You've got Paul Betancourt, the Republican, myself, and others all here before you advocating that you return control of the elections to elected Democrats. That's exactly what we need to do. In fact, we want to get away from this. As someone recently said, we had 5 in 5 years. Easy to stop that. Return it to the elected officials. The clerk, of course, is not the one running it. They hire people. In fact, it would be very similar to exactly what the EA is doing right now. It would just be couched under the clerk. And when you take heed as yourselves as state reps, you might have to fire somebody who messed it up. But it's not the clerk running it from the daily operations. It's not the tax assessor collector running it from the daily operations. They have employees who do the exact same thing. In fact, they'll probably be the employees doing it. But they're responsible and accountable to the voters. And that's why this needs to be done. So with that, I'll save any further time. I close.
Members, any questions? Thank you, Chairman.
Thank you, members.
If there's no objection, Senate Bill 1750 will be left pending. There is no objection. The chair hears none, so Senate Bill 1750 is left pending. I would just note for the record that no one in leadership from Harris County came to defend themselves. They had to rely on Mr. Hendrickson to come up with some ideas that they might have to replace things and repair things and do things, and not Rodney Ellis and not the EA, and nobody else showed up to defend them. The chair calls. The chair lays out Senate Bill 747 and recognizes Chairman Leach to explain the bill.
Thank you, Chairman Smith and Vice Chair Busey. Am I the last bill of the night? Okay, so I'm the only thing standing between you and your beds after a long day. So I'm going to make this layout quick. There's a couple witnesses here who have been here all day from back home. I want to thank them and give them the time to tell you what this bill is all about. Members, under current law, if a candidate in a primary runoff withdraws from the election, then the remaining candidate is the nominee and the runoff election is not held. This bill would give voters a true choice in who the party's candidate in the general election will be. Under the bill, if a candidate withdraws from the runoff early enough to be replaced on the ballot, then the candidate who received the third highest number of votes would be entitled to a place on the runoff ballot, and the runoff election would still be held. So hypothetical, right now, if there are three candidates this is a primary, in a primary election, and the first place candidate gets 49% of the vote, the second place candidate gets 26% of the vote, and the third place candidate gets 25% of the vote, then of course the first place candidate at 49% and the second place candidate at 26% are in a runoff. If the next day after the election or a couple days after the election, the 49% decides to withdraw, then right now there is no ability, there is no runoff election. There is no, the second place candidate wins. There is no ability right now under state law for there to be a true contest, a true choice for the people between the second and third place candidate. This would fix that. Under some pretty strict guidelines, some procedural framework that we've put forth in the bill. This was supported on a bipartisan basis out of the Senate, and I think this is about fairness. This is really about, I don't want to call it a loophole, but in a sense it kind of is a loophole. And so I think that we ought to give the voters a choice in that instance. It seems unreasonable, and frankly, it seems wrong to me that in that instance there would not be a runoff election and the second place candidate would waltz in. Third place candidate has no chance to be on the ballot in the runoff. So that's all this bill does. This is about free and fair elections. I'm happy to answer any questions, and I would respectfully request my right to close, Mr. Chair.
Thanks, sir. It's reserved. Members, any questions? Thank you. Thank you. The chair calls Thomas Burrows. Thomas Burrows. I show him testifying on behalf of himself and for the bill, 4747, and not here to testify. Wes Bowen. I show him testifying on behalf of himself and for SB 747 and not here to testify. Suzanne Harp. Good evening, Ms. Harp. Good to see you. Yes, ma'am. I understand you're here on behalf of yourself and you're for SB 747. Is that correct?
I am.
Go
My name
ahead.
is Suzanne Harp. I am for SB 747. And I just want to say, first of all, I am so thoroughly impressed with each of you for being here, probably in your 13th hour already. So thank you. You are Texas's best. And I want you to know that when I go back home, I'm going to be telling them that the representatives takes their jobs very, very seriously, and I appreciate that. And I'm just like you, I'm a little tired. I came in last night, but this is super personal to me. I was that third place candidate on the ballot, my first time running for public office, and we decided to run for Congress. We had over 150 to 200 volunteers, and we had most of them, of course, all unpaid. They're volunteers. And they knocked doors. We knocked more than 13,000 doors. And as you guys can remember, do you remember the first time you ran, what it felt like? Right, whether you are successful or not successful, you wanted everybody to be honored in that process. And this is really about honoring Texas at the end of the day. So I'd like to submit to you 2 case studies. I thought, I don't want to make this about me and my election. So let's think about what's going on in Texas law at large. Both Texas Land Commission and Texas Railroad Commission went to a runoff, with the second place person only having 15% of the vote. So God forbid, can you imagine something happening to Don Beckingham and our nominee having 15% of the vote? Irrespective if it's Republican or Democrat, you can imagine that nominee does not have the will of the people, and 85% of the voters are disenfranchised at that point. So what we'd like to see is you vote in favor for 747 and give Texas another opportunity to have their say in a primary runoff. So with that, I won't keep you guys much longer. I know that you're going to do the right thing, and I, again, respect you for the hours you put in and the dedication you put towards election law. So thank you.
Thank you, Ms. Hart. Members, any questions? No, thank you for staying so late and
Absolutely.
joining us.
I'm so impressed with you.
Oh, well.
Thank you.
Thank you. Thank you. The chair calls Christina Atkins. I think it's fitting that we may end with Christina Atkins tonight.
She's the best.
She is the best. Ms. Atkins, you're here on behalf of the Texas Secretary of State's office. I should say this, that you are the Director of Elections with the Texas Secretary of State's office, who you're testifying on behalf of, and you're neutral on SB 747, is that right?
Yes, sir.
Do you have any comments to make about this particular bill?
I do not.
Members, do you have any questions of our resource witness? Vice Chair Busey.
Just one quick question, and I don't have a strong opinion for or against, but this extends from 3 days to 5 days to be able to drop off. I'm just curious the reason for doing that. And maybe I need to ask the bill author, but is there any technical reason that we're doing that?
I'm not aware of a technical reason. I think it just gives people a little bit more time to make that decision.
Okay, thank you.
Any unintended consequences that you see from this bill, Ms. Atkins?
Nothing that's already been discussed.
Real
No, I
quick.
mean, it could result in another election, so.
One look. 3 to 5 days from the election results of the primary, is that?
From the canvas.
From the
Yes,
canvas.
uh-huh.
Does it have anything to do with the fact that Harris County takes longer to tabulate votes? Sorry, I withdraw the question.
Yes. Chairman Lee.
Thank you, Chairman. You just mentioned that it could result in another election. Is that what you said?
Right, it could force a runoff,
But the runoff was already going to take place anyways.
correct.
So it would just, it would prevent a runoff from not occurring in the situation where the first place candidate had to withdraw. Okay,
But-
I just wanted to clarify.
And yes, sir, and I'm sorry, I didn't mean to say that that was an unintended consequence. It was just,
Sure, right.
yes, uh-huh.
All right, members. Thank you. Is there anyone else who wishes to testify on, for, or against Senate Bill 747? The chair hears none, not even Ms. French. Okay. And so at this point, I'll recognize Chairman Leach to close.
All right, thank you, Chairman, members. I do want to mention this in closing. We all are here because we want our elections. And think about, I don't know about in the case of your elections, I've now run 6 races in my 6th term here. And I don't recall any of the losing candidates that I would defeated coming to the Capitol, taking part in the process, thinking through ideas, coming to meet with us, working to affect good public policy. And I just so appreciate Suzanne Harp, and there's others like her who could have not stayed involved, who could have, taken her loss more difficult. But no, she cares deeply about public policy, about making the state and the country better. And I just want to recognize her and congratulate her for that. This is I think it's a great idea. I didn't come up with my own, she did. And I think we need to pass this into law.
Members, any questions of the chairman? I have a feeling she'll be back.
I agree, yes.
Just don't move to Grayson County, please.
Yeah. So she will be back for sure. Thank you, Chairman.
Thank you. Yes, if there's no objection, SB 747 will be left pending. The chair hears no objection. SB 747 is left pending. Ladies and gentlemen, that's a wrap tonight for elections. I think if there's no other business, the chair is going to adjourn, subject to my call.